students, good morning. So we are live, right? अभी स्टार्ट नहीं हुआ, एक बार चेक करो आशीष. नॉट स्टार्टेड एट करके आ रहा है. हाँ, डन डन, वी आर लाइव. ठीक. Sorry for the interruption, guys. Good morning and warm welcome to JV's IAS. Welcome to discussion on Mark Mains Answer Writing Guidance Program. Okay. So, yes, very good morning, Kundan. Yes. Before we enter into the discussion of the test series, a brief introduction about me, because this is the first time I am taking the session. This is the first time I am interacting with you. My name is Gogula Rajashekar. A brief introduction about me with respect to what is my journey in UPSC, what is my experience, what are my qualifications. See, I am an engineer from IIT Bhubaneswar, and after that I have given 5 mains in UPSC and 2 interviews. Okay, both the interviews, they were close misses. I was very close to the cutoff. Then with respect to teaching, I have 5 years of experience, and from now onwards I will be taking your Mark discussion classes. Okay, and with respect to area of research and my research work, I have done research in artificial intelligence. I have patent in that and a couple of publications in journal papers. So that is all about me. Now let me discuss. Before I start, let me take up your queries, because I need your confirmation. My voice, everything is clear. And second, in the test discussion, where are we? Like, this is the test 1 part 3 discussion. You just have to confirm me from where we have to discuss. Okay, so that is the second thing. And before even entering into the test discussion, I wanted to give some general tips for mains answer writing. Okay, is that clear? Yes. Now the tips I wanted to give for mains answer writing. Yeah, tips for answer writing. See, all of you are very good with answer writing. You have started your answer writing, and some of you might have faced, like, I have not gone through your papers. So that's what I wanted to put. That's the reason why I wanted to put these tips, so that I can give you like some tips for good answer writing, for information management. Like, everyone talks about the time management in the examination. Like, it's all about the 20 questions which comes in the mains examination paper, and how we are going to approach them, how we are going to attempt them, and how we are going to represent them. So as I personally believe, each and every answer, like the way we write it, it is a kind of emotion that we are going to communicate with the examiner. So that sort of thing has to be represented in our answers. For that, there are some simple tips in the manner of the prioritizing the information that we have, and in the manner of like representing it. Like, this is an art, like, answer writing is an art. So there I wanted to give you some tips. Then we will enter into the actual discussion of the test paper once I get the confirmation from you from which question I have to discuss. Thank you, Kundan. Thank you, Vineet and Pooja. Very good morning. So before that, let me tell you the points which we have to keep in mind while writing the answers, while producing the very good answers. Sabse first, I hope you guys are comfortable in both languages, like Hindi and English. I'll use minimum Hindi, like I'll keep the composition 90-10. 90% will be English, only 10% or 20% will be Hindi. Okay. So the first point is, we have to attempt all questions. All questions. Okay, attempting all questions. So for attempting all questions, we have to take care of three things in our mind. We have to take care of these. Number one, what are the marks and what are the word limit for those particular questions. If you see the UPSC examination, we kind of come across three types of general questions with respect to word limit. One is the questions which are for 150 words and 10 marks. Another one is 150 words, 10 marks. Then you have 200 words and 12.5 marks. Then 250 words, 15 marks. So depending upon the number of marks awarded, we have to consider this word limit. See, adhering to these word limits it should be highly prioritized because two ways. It is going to help us two ways. It is going to maintain our objectivity with respect to the examination. Second is, when we are adhering to these words, we will be having good amount of time left so that we can attempt all the questions. This is what I actually wanted to talk about, because each and every topper, each and every person talks about time management, but nobody talks about information management. Like, I'll give an example. Information management. What I mean by this? See, there are some questions which comes in the examination which we know very well. We have huge amount of information. Being an aspirant, throughout our preparation, we have come across lot of information related to particular topic. But that particular topic has come for 10 marks. I'll take same concept and I'll explain how we are going to approach, how we are going to prioritize our information, how we are going to manage our information, so that we can, like the same question, let me take a random question related to coral reefs. Okay, there is a question related to coral reefs for 10 marks, for 12.5 marks and for 15 marks. How we have to manage the information depending upon the objectivity of the question. You know, all the jargons that come in the examination, we have given it in our themes. Like, so from there, depending upon what is being asked in the question and to what marks, to what number of words, we have to manage, we have to prioritize the information. Okay, prioritizing the information according to the demand of the question. When we are doing it, we will be able to like save some time, like stipulated time, whatever the time that is there for a particular question, we can save part of it and utilize it somewhere where there is a gray area, where we need some sort of thinking, where we need some sort of time in order to accumulate the information, accumulate the points and represent them in the paper. For example, like 150 words is the limit. Nobody in the examination going to count exactly whether you have written it in 150 words or 170 words or 130 words. So there is that, like plus minus 10 words, plus minus 20 words, that margin is there. So what I suggest to you is, when the question has been asked for 200 words, 250 words or 150 words, try to prioritize the information and try to complete the question less than or equal to that much of word limit. Suppose say if the word limit is 150 and if I am writing my answer in 140 words or even 135 words, there is no harm. But by doing this, I am going to save 15 words per question. If I do that for 9 questions, ultimately the 10th question, whatever the words that are required, that many words you have saved, that much of time you have saved, and for that question you will be able to spare the time. So are you getting how we have to manage the information? Like, depending upon the objectivity of the question and by adhering to the word limit, like don't go beyond that. See, some person who has good information, who wants to produce excellent answer, they might write it in 170 words. Thereby, they are going 20 words beyond that. What is happening because of that? This person who has written the excellent answers in, like say, 5 questions, he has spent 20 more words. As a result, what is happening? Like 100 words crunch is falling for some other question which is going to attempt at the later stage. So that crunch we have to avoid. Then it will be easy and it will be possible for us to answer all the questions. The point is clear here, right? And further, see, anyway, UPSC has a relative marking. Even if you produce excellent answers. So what is the maximum marks out of 10 you are going to get? It is close to 6 or maybe sometimes 7 if it is too exceptional, completely like it is completely novel from other answers, then you might get 7. Okay. But by doing this, in some other question which you can produce above average or a good answer where you can easily get 4 to 5 marks, you are going to lose that. So for that, what we have to do, try to manage the information, prioritize the information so that we can attempt all the questions. So there won't be any time crunch, and that extra addition or extra attempt of a particular question is going to give you like 2-3 marks extra. That 2-3 marks is more than enough to decide our rank, to decide our cadre, to decide our zone. So that 2-3 marks are going to be like, within that 1 mark range, there will be like 10-20 rankers. So in that, this 1 or 2 marks increment in your exact score, it is going to boost your cadre. It is going to boost what kind of service you are going to get. Is that clear? So that is the first point I wanted to say. Any doubt in this? Good morning, Solu Jain. Yeah. The second point I wanted to discuss here is representation. That is the diversity that we are going to keep in our answers, that we are going to present the answer, the way that we are going to present. All of you are good with the flow charts. We can go with flow charts. So by going with flow charts, we can also save time. Like what you need to write 100 words, that much of time, that much of information can be put in a diagrammatic manner in a flow chart. So that represents even better. Okay, better representation is happening, and it is going to reduce your time. Okay, time reduction. At the same time, information, like the first point, information management. Then you can add some of the maps or diagrams related to a particular topic. For example, if I am discussing about earthquakes, the seismic waves, the behavior of the seismic waves, we can always, like shadow zone of the seismic waves, we can always draw the behavior of S waves and P waves, the emergence of shadow zones. Like for example, this entire thing is going to be the shadow zone of S waves, and this particular thing is going to be of course, the nature is not exactly like this particular thing where we are not going to get the P waves, it is going to be the shadow zone of the P waves. So such sort of diagrammatic representation, it is again going to give a very good impact in our answers. Then comes the paragraphs. But remember, in answers, general studies answers, we have to keep our paragraphs to the minimum. Like don't go for more than 4 or 5 lines. Keep it to like 40 to 50 words paragraphs. Okay, paragraphs or bulletin points, pointers. So in this manner, if you are representing the information in diverse manners, for example, if you wanted to talk about some of the causes for, say, causes for pollution, causes for air pollution, we can represent it simply in this manner. Different causes, we can represent it and put it over it. So by that sort of representation, you are saving the time, you are saving the word limit as well, so that the space in the examination is also saved. At the same time, what you are getting, you are going to get better marks because of your good representation. So these are the main points that I wanted to discuss before entering into the topic. Now please some of you confirm from which question of test 1 we have to discuss. So from there onwards I'll discuss, I'll keep it like the structure. What we are going to follow in all these discussions is very simple. Okay, what we are going to do is, for each question we will be looking at the approach or the structure that we are going to keep it in the question. Then some of the hints through the model answers I'll be discussing, what points we have to prioritize, how we have to represent it. Okay, so that is, we are putting button under the body of the question or discussion of the question, then conclusion of the question. See here, introduction. Once we discuss the structure, then we will discuss what should be there in the introduction of the question, then the body, that is the demand of the question, then we will be going to the conclusion. And if the question is dynamic, if the question has any future perspective, any way forward, we will be discussing that, what should be done or what positive steps have already been taken, how those steps are going to be fruitful, how they are giving the positive results. All of them we are going to discuss under way forward. Okay, so in this manner we will be keeping this structure throughout all the questions. Static, we'll discuss whatever the relevant, because today's topic is polity and constitution. We will be looking at some of the constitutional provisions. At the same time we will be trying to link with the contemporary news. Is that clear, guys? Okay. Okay, so Vineet is confirming that we have to discuss from question 5 of test 1, and Pooja also confirming the same. Kundan is saying we have to discuss from 7th question. Okay, we have little bit of discrepancy here, but we will go with from question number 5 onwards, because majority of the people are saying from question number 5 we have to discuss. I'll take it up from question number 5 and discuss. So far, any doubts, guys? If you have any doubts, feel free. I am very much approachable. Okay, you can ask me. Even if you have any very minute doubt, you can ask me. I'll be much more obliged to help you. Okay. Yes. Okay, great. There is little bit of lag in the live. Okay, I'll wait for your comments, then I will start the question discussion. Okay. Yes, we are going to start from here. That is question number 5. Please go through the question once. Article 32 is the very soul of the Constitution and the very heart of it. In light of this statement, discuss the significance of writ jurisdiction of higher courts in India. Okay, so this is the question. See here, the jargon, the question, the demand, it is that we have to discuss it. We have to discuss it. Okay, discuss is the keyword here. And what we have to discuss? The significance of Article 32 and writ jurisdiction of the higher courts. Higher courts, what are the higher courts in India? They are High Courts and Supreme Court. So both of them have been given the writ jurisdiction. Okay, we will see what are they, what types of writs can be given, how they are going to help us, how they are going to be important, and why this particular Article 32 is called the very soul and heart of the Constitution. This is what we are going to discuss. Okay, so as I said, our discussion start with the structure of the question, that is the approach. See, in the structure we have three parts. Structure, basic three parts, that is introduction of the question, then body of the question, then conclusion of the question. These are the three main parts that will be there in each and every question. So let us see the approach in order to come to this kind of structure. In our approach, first what we have to do, the introduction we have to write. So introduction, we'll always keep it very, very simple, very clear, cluster. So here the introduction should be on article number 32 of the Constitution. So introduce your answer by mentioning how this article 32 is important as far as Constitution is concerned. So what is the importance of 32? The constitutional remedies, and not only that, it is not only defending all the fundamental rights, but itself, the 32 itself is a fundamental right, and because of it, the Supreme Court, it can never reject, like I'm not going to take any plea related to article 32. It can never say, because it itself is a fundamental right. It has to take. There is an obligation on the Supreme Court. That's why. So that is the reason why article 32, what it does, it defends the fundamental rights, and it also guarantees the fundamental rights. Defense, in the sense, if there is any infringement into the fundamental rights, using 32, we can go to Supreme Court directly without any appeal. We can directly approach the Supreme Court. And guaranteeing, because 32 itself is a fundamental right, and there is an obligation on the Supreme Court. It has to take it up. Okay, that too by the direct appeal. It doesn't have to go through the steps. Okay, that is the reason why it is the very important article. Okay, then in the body we will be explaining what is the meaning of this writ jurisdiction. Okay, and what are the different types and nature of the writs that we have. Okay, particularly to enforce these fundamental rights, to defend them, we have 5 types of writs. We will look at them. Excuse me. Then we will be providing the significance of these writs, how they are going to help us in making Article 2 the very heart and soul of the Constitution. Then finally we will conclude it. Is that clear, guys? So let us go ahead. Yes, in the introduction, what we have to write? We have to write about Article 32. Article 32 is in which part? In the part 3 of the Constitution, which deals with fundamental rights. So these fundamental rights are from Article 12 to 35. In that, 32 is there. So part 3 of the Indian Constitution, and it deals with protection of fundamental rights. As I said, Article 32 ensures the defense of the fundamental rights, the protection of the fundamental rights. Whenever there is infringement of these fundamental rights, each and every citizen has the right to directly go to the apex court for their defense. And Article 32 itself is a fundamental right because it is falling in the part 3 of the Constitution. So the courts, the apex courts, have to take up those cases. There is an obligation. So that is why this is said as, Article 32 said as the soul of the Constitution, because it makes the Supreme Court both the guarantor and defender of the fundamental rights. I told you why defender, it has to defend the fundamental rights. Why guarantor? Because Article 32 is mandatory on the Supreme Court. Whenever there is a plea, whenever there is a case, whenever there is a PIL or whatever may be the plea, the Supreme Court has to take up that. It can never say no. Okay, so that is the reason it is a guarantor of the fundamental rights. Now this writ jurisdiction under Article 32, and the same kind of responsibility has been put on the below courts, like just below the Supreme Court, though they are high courts. On them also, using Article 226, this obligation has been put. The writ jurisdiction has been put on them. So here we will be looking at, see, the question is not asking about the differences between writ jurisdiction of the Supreme Court and High Court, but I'll just give a brief introduction. Okay. See, 32, it is mainly used to give writ jurisdictions, which we are going to discuss, to the fundamental rights, to the implementation, or in order to safeguard these fundamental rights, only fundamental rights. So Article 32 empowers Supreme Court to give writs for defense of the fundamental rights, whereas Article 226 gives power to all high courts of India, different states, high courts of different states, they have writ jurisdiction. However, here the writ jurisdiction is little bit wider than writ jurisdiction of the Supreme Court, meaning high courts, they not only give writs for implementation of the fundamental rights or defense of the fundamental rights, but it can also give it for other purposes. That is the reason why high courts has wider connotation, wider scope with respect to the writ jurisdiction. So having understood this difference, let us enter into the actual part of the question. So Article 32 and 226 of the Indian Constitution provide for right to the constitutional remedies. These are called constitutional remedies because if there is any infringement, if there is any problem, what we are going to do? Using these, we are going to approach to the courts for remedial purposes, for remedy. So that nuksan hua bhai, hame do the remedy, give us the justice. So through these articles we go to them. Okay, that is the reason why the constitution maker, like the chairman of drafting committee, B.R. Ambedkar, who is regarded as modern Manu, okay, because he has framed, he has drafted the constitution. That's why, because the rule book, that's why he is known as even modern Manu. He has said that it is the heart and soul of constitution, because without this guarantee, without this defense, we cannot ensure the fundamental rights. There are list of rights, and as soon as these are not enforceable, so this is a justiciable part, that is, they are enforceable by the courts, court of law. So if they are not enforceable, there is no effect. So to make them enforceable, this article has been put in the constitution. That's why this is the very heart and soul of it, because it ensures the fundamental rights to the citizens. Is that clear? Now let us look at the types and nature of the writs. So what is the writ jurisdiction, and what are the types, different types that we have, and what is the nature of them? So we will be looking under Article 32, because the question talks about Article 32. That's why we will be looking at the writ jurisdiction under Article 32. Under Article 32, we have 5 types of writs. Let us see them. What is their ambit, what are their names, and how they are going to help us in defending the fundamental rights, right? Subse first, habeas corpus. Habeas corpus. It literally means have the body of, like some person who has liberty, Article 21, liberty and right to life and liberty, personal liberty, freedom of expression, view 19. So who has these fundamental rights? If such a person has been detained, if such a person has been arrested, confined, in such a cases, the court issues habeas corpus. The person whom you have detained, the person whom you have confined, bring that person to us. Bring them in front of us. Have the body of that person. Is that clear? So this writ, what is the nature of this writ? It asks for bringing that confined person or detained person. There are some exceptions, we will discuss some other time, not here. Okay. So have that body, and it is considered to be the bulwark of individual liberty, because it ensures the individual liberty, because when somebody is confined, you are making that person to be in front of the court, and depending upon the kind of whatever the action that he has done, if it is constitutional, if it is legal, the person will be set free, so the liberty is ensured. If not, if there is any wrongfulness in his actions, then according to the procedure established by the law, then that much of punishment will be given to that person, then that person can be confined. Okay, so that is the reason why it is the bulwark of individual liberty against all illegal and unjustifiable detentions only. Like illegal, if it is legal, then even habeas corpus cannot save you. Like if the action is illegal, then it will be put behind the bars. Okay, detention might happen. So depending upon the crime, depending upon the illegal activity that we have done, otherwise you will be set free. Okay, and it can be filed by any person on behalf of the other person. Like it's not necessarily the aggrieved person, it can be any person. Suppose say I have been detained by some person, so having in that detention, having in that confinement, how can I file for myself? So for that purpose, somebody, a friend of mine, a family member of mine can be, that person can file this petition and you can get the writ. Okay, and it can be issued against both public and private individuals, public authorities such as police, okay, or private individuals, any individual. So please remember, this is very important for prelims as well. See, habeas corpus can be filed against both private individuals, private entities and public entities. Okay, so now, so far any doubts in this? Okay, is that lagging, Pooja? Guys, is there any lag in that? If there is a lag, please put it in the comment box. We will take care of it. Okay, thank you. Right, now let us go to the next writ that we have, that is certiorari. Okay, certiorari. See, before going into certiorari prohibition, let me discuss about mandamus. This is the second writ that can be issued by a Supreme Court. So what is the meaning of it? It literally means we command. We command. Okay, so by the mandamus, it meant an order that is passed by superior court, in which that court orders a lower court or a government agency or any public authority to do or refrain from doing any act which is otherwise in conformity with the law. Okay, that means it will command to do your duty, perform your duty. You are a public authority, you are a public agency, you have to perform your duty. Since it is telling, it is commanding some public authority to do its duty, so it is only available against the public authorities. It cannot be issued for a private entity. Suppose I am a private individual who has opened some shop through which I am providing some services. Now the court cannot come and it cannot demand me to perform a duty. It's mera marzi hai bhai. Agar if I am comfortable, I'll do it. If I am not comfortable, if I am not well, I won't do it. Okay. So some sort of restriction is there. So it can be given for only public authorities or public entities. Okay. So this is the second writ, which is known as mandamus. Now let us go to the third one, which is prohibition. See, prohibition, what is the meaning of prohibition? To prohibit something, to stop something. Okay, so this is given, this writ is given by higher court to the lower courts, that a particular issue is there, you don't do it, because by doing it you might exceed your jurisdiction. So it's not falling under your jurisdiction, or we have interest in this, we are going to take it up. Okay, so for that purposes, if they are going to infringe into the jurisdiction or they are going to exceed their jurisdiction, then this sort of writ will be given. You are going to enter into somebody's personal space, or you are going into that location where you have no authority, where you have no jurisdiction. So don't do that. Such sort of thing, such sort of writ is known as prohibition. This writ is prohibiting, like मना करना, नहीं आप नहीं कर सकते. Okay, so that is prohibition. Now next वाला, see prohibition क्या कर रहा है? Prevent कर रहा है. It is prohibiting, it is stopping, मना कर रहा है. But certiorari, which is another writ, it is also given by higher court to the lower courts or tribunals. For what purpose? Like you are going to enter into somebody's jurisdiction, so don't do that. It is not in your hands. Rather, it is the work of some other court, some other authority. We will be delegating, we will be giving it to some other person, some other authority. So, by certiorari, what the court is doing, the higher court is prohibiting the lower court or a tribunal from entering into the jurisdiction of somebody else. They are prohibiting it. At the same time, like it is preventing, at the same time, it will be curating. It will be like a curative. So, this is not your work, somebody else is there, let that person do that work. So, it is preventive as well as curative. It is not only stopping at the prohibition level, but it is also providing the solution for the future. So that writ is known as certiorari. Is that clear? And here, please, for example, the Supreme Court exercised certiorari in AK Karai Park and Union of India, in which selection process was squashed on the ground of biases. On the ground of biases, there is a selection process that has been prohibited. You do not have this authority to select on the biases basis. So it has been stopped and concerned authority has been called to take care of that selection process. Is that clear? Now going to the final one, which is quo warranto. What is the meaning of, literal meaning of quo warranto? It means by what authority. Suppose a particular person has occupied some position. If as that person has hold some office, then the court will ask that authority, that particular person, that particular authority, like by what authority you have taken up that position. So it literally means by what authority, what is the legal or constitutional authority or a provision that has given this right so that you can sit in that position, you can officially take that office. So they will be questioning it. So in which the court asks the ground, like qualification, what are your qualifications, on what basis you have been selected for this, and what basis you are occupying this particular position, okay, in which public servants has been appointed. So these are all the 5 important writs. So any doubts in this? Okay, Kundan, Vineet, there is no lagging. Pooja, please, if you are still facing that lagging, just refresh it. Okay, sometimes because of network issues we may have this lagging issues. Okay, now the second portion of the question, like the demand of the question, we have to look at the nature of the writs, like what are those writs and their nature of their writs. Now let us look at the significance of these writs. Okay, what is the significance of these writs? These writs are crucial in the defense of the fundamental rights. If you see, ranging from habeas corpus to quo warranto. Habeas corpus, if anybody is wrongfully detained, bring that person, liberate him, liberate her, give the freedom. So fundamental rights have been ensured. Okay. Second, mandamus. If public authority is not doing its work, then obviously the people will suffer. They will not get their fundamental rights. So there the court will be commanding them, do your duty. You are sitting here to serve these people, to ensure that these people get the justice, to ensure that they can have their fundamental rights. So to perform your duty. Then third, the prohibition. If they are exceeding, if the lower courts are exceeding their jurisdiction, thereby infringing into somebody's fundamental rights, then the higher court will stop it. You do not have this authority to infringe. Stop there. Okay, hold on there. Now, certiorari, it prevents, at the same time it will be giving it to the concerned authority. This is your work, this person is exceeding the jurisdiction, you don't do it, you do it. So this is a preventive as well as a curative measure. Then finally we have quo warranty. If some person forcefully or illegally or in any other means, if that person is holding any public office, then there will be question by the courts by what authority, by what measures that you are holding this office. What is the, so in all these writs, if you see, they are, what they are doing, they are trying to defend our fundamental rights. So that is the reason, the first and foremost significance of these writs. These writs are very crucial in the defense of fundamental rights, and without them, the part 3 of the Constitution, in which these fundamental rights have been enshrined, which is known as Magna Carta of the Constitution, so it has no meaning. It will be meaningless, and because they give teeth to the rights. Teeth to the rights matlab, without teeth, say, I can give one example so that we can connect with this. Teethless tiger, toothless tiger. Like if the tiger does not have any teeth, then it is harmless. It cannot do any work, it cannot hunt, it cannot eat, it cannot do any effective function. So in order to perform its functions, in order to have its significance, it must have teeth. In the same sense, it has been said, teeth to the rights. It provides legal remedy in case of breach of the fundamental rights. Okay, so that is the first significance of writs. Now, they are powerful checks against the excesses committed by the state, like the public. We have seen mandamus. If they are not doing duty, what we will say? Do your duty. The court will say, no, you have to perform the duty. As under Article 12. Article 12 defines. Article 12 has the definition of the state, in which the definition of the state is very, very broad to cover even the private entities which are doing the work of the government. Even those private entities which are doing like a kind of delegated function, or a kind of even the construction activity, like tender aa gaya construction activity do. So even that falls under the definition of the state. Such wider scope of definition of state here. Now it helped in bringing justice close to the disadvantaged sections, because here you don't have to be the aggrieved person to file all these writs. Even the non-aggrieved person on the behalf of the aggrieved person can file all these petitions. That's the reason, that's the beauty of it. Then using them, judiciary has interpreted many other rights, like we have judicial review, through which the judiciary will be reviewing the constitutionality of the laws, constitutionality of the provisions, constitutionality of the executive actions. So in these writs, they have played a very, very important role in ensuring the fundamental rights. Okay, so this is another one. For example, Menaka Gandhi case. Okay, now the next one is power of Supreme Court under Article 32 of the Constitution are limited only to the fundamental rights, because this point I have covered earlier itself. In the very first discussion of the question, I told you what is the difference between Article 32 and Article 226. 32 for the Supreme Court to give these writs for the Supreme Court's writ jurisdiction, whereas 226 is for the High Court's writ jurisdiction. Now the writ jurisdiction of the High Courts is wider, because it is not only for the fundamental rights but other purposes. It can give the writs for even the civil matters. Okay, but for Supreme Court it is strictly to the fundamental rights. That is why it is little bit narrower. Okay, so the same point has been highlighted here. Now having understood these bodily parts, now let us come to the conclusion. So remember, this is a 10 marks question. We have to stick to our objectivity. The objectivity is 32 constitutional remedies, why it is called soul and heart of the constitution, what is the nature and significance. All of the points have been discussed. Now the conclusion. Always remember, our conclusion, being a civil servant, the aspirant of civil services, our conclusion has always have to be optimistic in nature. Okay, optimistic, like positive conclusion, positive way of ending. Even if you are having serious threats, serious problems, in that also, in your conclusion, you have to give a ray of hope, a ray of optimism. Then it shows that you are optimistic and you wanted to bring the change and bring the necessary change in the system so that we can move ahead with that developmental goal. Okay, so that is the reason. Now let us look at the conclusion. The importance of the writs lies in creating permissible areas of exercise of the power, like where this power can be exercised, and authority, jurisdiction over administrative actions. Of course, legal actions and administrative actions enforced by any state. So when the state is doing the functions, legal functions, administrative functions, these writs ensure that the state does not encroach upon into the fundamental rights. It will be within the limits. This is ensured by these rights. It can be said that the judicial writs are constitutional remedies provided to the courts to keep the administration within the ambit of law, procedure established by law. Okay, so with that note we are trying to conclude it. So that is how we are going to say this Article 32, which is the writ jurisdiction of the Supreme Court, is ensuring the effectiveness and ensuring, defending and guaranteeing the fundamental rights of these citizens. Is that clear, guys? Now I'll take up your questions. If you have any doubts, please comment. I'll address them. Okay. Vineet, yes, absolutely you are right. That is what I was saying. We have to ensure our space and information. You are absolutely right. Since it is a model answer, we try to provide as much of information as possible. Yes, the word limit in this particular model answer has exceeded. For that, what we can do is, you just give the brief introduction of writ jurisdiction under 32 article, how it is ensuring the how it is going to ensure the defense and guaranteeing of the fundamental rights. That's more than enough. Now directly enter into the body. In the body we have to write what is the different types of, like, scope of nature of article 32. So what are the different types of? 5 types of writs that we have: habeas corpus, mandamus, prohibition, certiorari, and then quo warranto. So just one liner for each of them, like what is the meaning of habeas corpus, mandamus, prohibition, certiorari, and quo warranto. Then come to that significance portion. So in the significance, again, significance of them. Okay, in the significance, you can simply say they defend our fundamental right. They are acting as a check and balance on state, the action of the state. So some of them are available even against the private individuals, like the very first one, habeas corpus. So they will also check the the behavior of the private individuals. Then they ensure and guarantee your fundamental rights, and they are torch bearers or lighthouses for the judiciary in the judicial interpretations. In this manner, 5-6 significant points just write it, then conclude it. Then within the time, within the space, within the word limit, you can completely answer the entire question. Vineet, is that clear? Now, okay, Pooja, it's fine now. Okay. Then Arya. Yes, Aryan, what is your point? That what is your question? You are saying how to develop brevity. Okay, Vineet. Yes, Aryan. What is your question here? How to develop brevity, like brief expression. How to see? It's a simple. It's very simple. Like, what is your objective of the question? Let me go back to the question. See, the question objectivity is very simple. Here they are asking, like, Article 32 is the very soul of the Constitution and very heart of it. In the light of this statement, keeping this statement in the mind, discuss the significance of writ jurisdiction of the higher courts in India. We have two higher courts, one at the state level, that is the high courts. So related to that, writ jurisdiction is ensured by 226 article. So with that, with respect to that, we have to talk a little bit. Then the second one is with respect to Article 32, which ensures writ jurisdiction of the Supreme Court. Okay, these 2 points, that is our objectivity. And then discussing about all these, we just have to conclude how this has become the heart and soul of the Constitution, because they are going to ensure, they are ensuring, they are defending, they are guaranteeing your fundamental rights. So without which the entire independence and everything has no meaning. So that is the reason why these are very important. So by keeping the objectivity of the question in mind, we can ensure brevity. We can ensure that brief expressions. I hope that is clear, Aryan. Yes. One more question, Vineet. You are saying is that we have to entirely use the space which is available. There is no absolutely such sort of like condition. It depends upon how you are managing the information. See, sometimes, I'll give you an example. I think it is 2017, okay. In my GS paper 3, I left one question completely. I could not attempt it, okay. The lack of knowledge or time, I could not manage it, or so and so. Remaining 19 questions I have answered. And in that also, all the then 10 markers, 10 questions, 15 markers, 10 questions. That is the pattern that we are getting. So in that also 15 markers, like 4 pages will be there in the UPSC for 15 markers. I was doing like 3 pages, 3.5 pages, not completely 4 pages. I thought like every time I'm half of the page or 3/4 of one page I am leaving. So they might cause like less marks for me, and I was expecting lesser marks in GS 3. Surprisingly, I got one of the good marks. I got 118 in GS paper 3. So it is not about whether you are using complete space or not. How good, what are the points that you are putting, how relevant those points to the demand of the question, that is going to matter. Okay, is that okay, Vineet? Yes, Aryan, okay, clear. Great. So let us go ahead, guys. Let us go ahead and see the next question. The next question is very important, like it's a kind of dynamic question. Here also lot of information is there which you can skim. We have, see, the motive behind providing these model answers is we wanted to give you more information related to all of it. Out of this information, you can skim it, you can reduce it, and take that information which is related, which is relevant to that particular question. The only reason why we are providing more information here is if any question related to this particular concept comes, this information is going to come handy in the examination. That's the reason. See, these are all not exact answers, these are model answers. That's why we are trying to provide little bit of extra information. Okay, now let us go to the next question. which is National Green Tribunals. The question on National Green Tribunal, NGT. So the question is National Green Tribunal, which ensures the environmental justice in the country itself facing very important question, itself facing many issues and challenges, critically examined. Now all of you are equipped with what is the meaning of critical examination. Examination means elaborative analysis of that particular topic, looking at both entire ambit of it. Now critically, we have to have a balanced judgments by looking at pros, cons. In this particular thing, we have to look at what are the issues and challenges that they are and how they are putting itself in problem in ensuring the environmental justice. So that is the demand of the question. Now here, if you look, the word limit is 250 and the marks are 15 marks. So let us try to structure our answer according to this demand. So the structure, the approach will be what? First, let us give a brief introduction about what is the meaning of NGT, National Green Tribunal, how it has been formed, what are its functions, okay? Then let us mention like its legal and constitutional provisions. You might ask me, sir, NGT is a statutory body, meaning it has been made, it has been established by the law of the parliament. Then why you are mentioning constitutional provisions? It is not a constitutional body. Here the meaning why we are putting these constitutional provisions is, in order to ensure the environmental justice, there are many constitutional provisions. Look at your preamble, you find there is a provision related to protection of the environment, ensuring of the environmental justice. Again come to the part 3 of the constitution, which is fundamental rights. In that, protection of the environment is there. Again go to the DPSP, there is a duty on the state to ensure environmental justice. Come to part 4A, which is fundamental duties, article 51AG. Okay, in that there is a duty, fundamental duty on each and every citizen of the country to ensure the quality of the environment. So these are all the constitutional provisions which are available with respect to the protection of the environment and ensuring of the safe and healthy environment. So that is the reason why to mention them. Then to give effect to these constitutional provisions, we have made this body NGT through the Act, legal act, National Green Tribunal Act of 2010. We'll discuss about it. Then in the second, mention how NGT ensures environmental justice. This is where we have to focus upon the objectives of the NGT, the functions of the NGT, some of the rulings, some of the judgments given by the NGT. Okay, and in the third, let us provide the issues and challenges that are associated with NGT. What issues it has been facing, what are the challenges in ensuring the environmental justice. Then finally, conclusion and way forward. See, it has a future perspective. Whenever there are challenges or issues that can be addressed, so it is expecting, the UPSC is indirectly expecting from you what kind of measures you can suggest. So those challenges, those problems can be reduced so that we can have the ensuring of the environmental justice by NGT. So that is where we have to write the way forward. Is that clear, guys? Approach is clear, the structure is clear. Any doubt in this? Okay. Okay, before entering into the answer, we have two queries. Vinith is saying, like, please explain. Let me keep this closer to me. Okay. Vinith is asking, can you please give an idea how to effectively present an answer on the paper? Definitely I will give it. Then second is Pooja. Pooja is asking, sir, please also explain static relating. Yes, of course, Pooja. Whenever the topic comes, which is related with the current affairs, which is related with the more news, I'll try to recall, I'll try to link with that. Okay, definitely I'll implement it. Yes. Now, representation, like in between I'll make some space and I'll give you how to represent it. What kind of diagrammatic representation or flow chart representation we can do it. That I'll definitely ensure it, Vineet. Now, let us go ahead and look at the answer, model answer of this question. As I said, in the introduction, we will be writing about National Green Tribunal. Okay, see here how it has been established. As per the National Green Tribunal Act of 2010, it has been established. It is a specialized judicial body, okay, equipped with expertise solely for the purpose of environmental, like adjudicating environmental cases, so that we can ensure environmental justice. This is the main reason. Okay. Now, it is tasked with providing effective and expeditious remedy in cases relating to environmental protection, conservation of the forest and other natural resources, and enforcement of any legal rights relating to the environment. See, if you can, again, let us link it with our environment topic. In our environment, we have concepts like protection, like preservation of the environment, then environmental pollution and degradation, conservation, and environmental impact assessment. In all the four aspects of it, NGT is playing a very, very important role, even in the environmental impact assessment. So whenever the environmental impact assessment is done, when it is put to the public domain, NGT can take up the case on suo motu basis by itself if there is any problematics, if there is any problems in that particular EIA. Okay. Now, this is the basic introduction which talks about how NGT has been established, what are its objectives, so that it can ensure environmental justice. So this is our introduction. Now let us enter into the next part, that is body, where we will be looking at how it is going to ensure the environmental justice, which is the demand of the question. See, in the demand of the question, please again recall what we have to take care. Like, it has been established to take care of the environmental justice, okay, and environmental justice, and it itself is facing some problems and challenges while doing that. How can we reduce it? So how can we do the critical examination of this? That is the demand of the question. Okay. So let us look at how it is ensuring the environmental justice. Sabse first, legally enforce all the rights related to the environment. Meaning, see, in the constitution, in the provisions, only those which are in the third part of the constitution, which are in the fundamental rights, are enforceable. The ones which are outside it, either in the preamble or in the directive principles of state policy or in the fundamental duties, they are not. For their enforcement, different acts have been made by the parliament. Okay, different acts. Let me recall, like Water Pollution Prevention and Protection Act, Water Act, or Wildlife Conservation Act, Biodiversity Act. So take any of the examples. Such sort of acts have been made. Now the effective implementation of the act. If there is any problem in this act, if there is any issue with these acts, if anybody is not adhering to them, if they are willfully defaulting them, what? It will enforce legally. So that is the first function of it. It aims to do that. Then related to this environmental degradation or related to environment, any cases comes, any petitions comes, they are taken up by the NGT, and it will, like, it ensures the speedy disposal of them, at the same time effective disposal, so that environmental protection and other natural resources protection can be ensured, thereby ensuring the environmental justice. Then provide compensation and justice to all the affected people in case of any damage. Can you guys recall the case of Vedanta? Like when it has been given, there is a tribal area in Odisha, Niamgar tribes. Okay, in that particular area has been given to Vedanta for mining, but environmental impact assessment, it has said that it is going to be detrimental. Then after that, it has been reversed. The entire contract has been called off and it has been reversed, and the land has been given to the tribal people again. So that is one example you can say. So whenever there is damage or when some people are affected, like if there is a large developmental project, as a result many of the people are going to be affected and they have to be rehabilitated. They have to be relocated to some other locations. In such a cases, it ensures that they have been duly compensated. They have been given all the basic amenities. At the same time, it also ensures if there is any effect on the environment because of these projects, it take care of that. I can give one example, like this Kampa. You might have heard about it. Compensatory afforestation. Suppose if there is any developmental project, as a result part of the green cover has to be cleared. To compensate it, the organization or the entity which is taking that land, it has to plant at least 3 times of whatever the plants that have been cleared off, and it has to ensure the life of those plants. At least 80 to 90% of the plants has to be living. Okay. So these are all some of the examples, we can link it here. Now apart from this, the decisions of the tribunal are binding. They are binding in nature. Okay. And the tribunal's orders are enforceable as the powers vested are the same as a kind of a civil court. So it has the same effect as of a civil court, and whatever the judgments given by this NGT, they are binding on the parties and they have to follow this. Okay. So that is how it is ensuring the environmental justice. The example like current affairs case has been given, like in this case, like solid waste management rules have been strictly followed. Okay. Say 2016, you see many rules with respect to waste management. It can be solid waste management, or it can be biomedical waste management, okay, or it may be e-waste management. Here I have to talk about one particular thing which is called extended producer, like EPR. You might have heard about it. UPSC asked a question related to this concept as well. Extended producer responsibilities. What is the meaning of it? If a producer is producing any goods or services which are harmful to the environment, then there is a responsibility on that particular producer to alleviate it, to reduce it, to take mitigating measures related to that. Example, suppose I am a plastic items producer. So because of the plastic there is environmental degradation. So there is a responsibility on me. Whatever the items that I produce, I have to recover them. I have to recall them. Like once their use is done, I have to collect it back and start using, reusing or recycling. That sort of responsibility has been put on the producers. Okay, this is one concept related to this. Then let us recall one more topic which was in the current affairs. This concept is called Polluter Pay Principle. Polluter Pay Principle. The person, the entity, the organization which is responsible for the pollution, whatever the amount of pollution that has happened, in order to compensate it, that particular person or entity or organization has to pay the money. Okay, this has been introduced by NGT. Okay, the very one which we are discussing about, the compensation, it has to be given. So these are all some of the examples which we have given here. Now with this, the first portion of it, how it is ensuring the environmental justice, is over. Now let us look at the second portion, which is the issues and challenges. So far any doubt, guys? Cool. Yes. So issues and challenges associated with the NGT. सबसे first, lack of environmental fineness of its expert members. Like it has many expert members. They are specialists in one particular field but not on the environment as a whole, because environment has many sections: air pollution, water pollution, soil pollution, or we can talk about noise pollution in terms of pollutions. And in terms of diversity, in terms of protection, we have flora and fauna. And in terms of environmental impact assessment, in terms of different fields, we have different entire stream is there in that environment. Now when we have expert members, those expert members, they are specialized in one particular field. The persons who are specialized in abating this air pollution or taking the disposing of the cases related to air pollution, and those persons may not have any idea, may not have less expertise with respect to biodiversity. As a whole this environment, they are lacking the environment. As a result, they are lacking these skills, they are lacking this expertise as a whole. As a result, the effectiveness of this is declining, is reduced. Okay. So for instance, an expert member who has been working on the forests for many years would not be able to comprehend the challenges arising out of industrial pollution. जस्ट उल्टा दिया था मैंने एग्जाम्पल, मैं बोला था जो एयर पोल्यूशन का एक्सपर्ट है, he or she may not have any idea related to diversity. थोड़ा यहाँ पर उल्टा एग्जाम्पल दिया है बस, ठीक है. सो दैट इज वन प्रॉब्लम. नेक्स्ट, as noted earlier, section 4 of NGT, you don't have to remember it, we're just giving the information. You can simply say NGT Act ensures these members, like you have a full-time chairperson and not less than 10 judicial and 10 expert members, ठीक है, subjected to a maximum of 20 full-time judicial and expertise members. Now these judicial members, they may be lacking expertise in the environmental field, and those expert members, there is already issue with these expert members because they are from different fields of the environment. And second thing is, these expert members may not have sound knowledge in the judicial field to what punishment, to what act, how much punishment has to be given. So in that they may be lacking it. So that is another issue. However, in the last 9 years, the NGT has never got the minimum strength. Like minimum strength is what? 20? Sorry, maximum strength is 20. Okay, but however, because of this lack of recruitment and lack of resources, you can say, as a result, this 20, the maximum number of people, has never been accommodated, like the 10 judicial members and 10 expert members, to address this increasing number of cases across the country. But with only 4 judicial members, as of now we have only 4 and 2 expert members. So you can say, you can cut down entire information, like what Vineet was saying. You can cut down entire information and simply write, Aryan is also saying the brevity. Okay, you can simply reduce this entire information, say NGT is under with respect to the personnel, it is understaffed. Okay, it has less number of people, though the act, it has the limit, you can go up to 20 members. But still, as of now, we have only 4 judicial members, 2 expert members. If the number of people are less And on the other side, the cases related to environment are rising day by day. You are getting more and more number of cases. So we need more people to expediently and to speedily reduce those cases, to tackle those cases. That is one of the objectives of the NGT. Why NGT has been formed? In order to take care of those particular cases related to the environment and to address them speedily and expediently. Okay. So that is one issue. Then the third issue is NGT has authorities similar to law enforcement agencies, but it is not like a regular court because it is a tribunal. Tribunals, they do not follow the like CPC, CRPC and all. They work on the principles of natural justice. Okay. Further, their enforcement, the functions, the kind of powers it has, they are limited. Okay, it's not like a traditional court. So it has less powers, so that the disputes, adjudication of the disputes, there is a limitation on it. So that is another issue. So next, NGT has the power of enforcing the laws on administrative agencies. It can only issue recommendations for punishments. This is the point that we have to highlight here. Like whenever there is a case, it is disposing, then so based on whatever the analysis that it has done, it can recommend, it can never enforce directly. It can recommend these are the punishments that you have to take, and that can be implemented by some other one. So depending on the nature and the gravity of the offense, the punishment will be recommended by it. However, such punishments can be challenged in a court of law, which is the final authority, limiting the tribunal's role. Meaning, though it is binding, still whatever the judgments of the NGT are there, whatever the punishments are there, they can be challenged in a court of law. And if the court gives otherwise decision, then that will be final. Entire the process of this NGT, everything has been nullified. So that is another issue. Then NGT Act mentions that green court's decisions can be challenged before the Supreme Court, even in the apex court. In spite of this, petitioners have been invoking Article 226, which is related to High Court's writ jurisdiction. So they said that whatever the decisions given by the NGT can be challenged in the Supreme Court. But in spite of it, many of the petitioners, they are reaching up to the High Courts through 226. Okay? So that is one more issue. Next, this is possible because of a loophole in the Act which doesn't specify that NGT orders can be challenged only in the Supreme Court. Had it been mentioned explicitly, whatever the decisions given by the NGT can only be taken up by the Supreme Court. If you are not happy with the decision or not happy with the judgment of the NGT, you can approach to the Supreme Court only. Then it could have been taken by the Supreme Court. Since that only is not there, that's why they are taking the loophole and they are reaching up to the lower courts like High Courts, and that too what? Using 226. That is the writ jurisdiction of the High Courts. This is another issue, another challenge which is reducing the efficacy of NGT, which is the reducing the functional role of NGT. Okay. Now, there are also serious challenges as far as implementation of NGT orders. Like it has given some order, the implementation of it. Let me give one example. Like it was 2016 onwards, the pollution levels in Delhi are increasing heavily. Then it has banned, NGT has passed an order banning all the diesel vehicles of age 10 years or so. Even after that order, like 2-3 years of that, the Delhi government was not implementing that order. When the NGT asked why you are not implementing, the government said we do not have the data of these vehicles. Okay, as a result of it, we are not able to ban it. See, look, the order has been given since still the government is not implementing that order. ठीक है. Okay, yes, this has been discussed. For example, Rule 35 Clause 1 of this Act specified that compensation, like this can be another example I can give for non-compliance of the orders of the NGT. Sometimes it gives the compensation, you have to see, it recommends this much of compensation has to be given. So now whether it is given or not, it is completely in the hands of the governments. Okay. So that is the another issue here. Okay. So we can trim this one, we can trim this entire information, we have given more information, you can trim it here. Then another thing is, invariably it is observed that the polluters don't abide by this rule, like the Polluter's Pay Principle wala rule, ठीक है, compensation amount का, ठीक है. Then the NGT orders are increasingly challenged in the Supreme Court, not only in the Supreme Court, even in the higher courts, because of the loophole. As a result, there is a tussle, like the order of the tribunal has been taken up by the courts, and again there will be another judgment related to it. Sometimes it may go along with the decisions of the NGT, or it may be against it. Okay. So if it is going along with it, well and good. If it is against it, it is going to reduce the significance of NGT. That is another issue. Further, whether along or against it, it is going to reduce the time, okay, the implementation time, and the impact, the effectiveness will be reduced. Okay. So that is another issue. There is no institutional mechanism to ensure that environmental regulatory authority is comply with the orders of the tribunal. Like we have different bodies, let me say CPCB is there, SPCB is there. What is CPCB? Central Pollution Control Board, State Pollution Control Board. So sort of different authorities are there. Now if these authorities are not complying with the orders of the NGT, then there is no effect of those orders. Okay. So that is another issue. Now these issues we have provided elaborative information. You can skim them, you can represent them in the bulletin points, like 4 or 5 issues. What are the issues? Let me quickly summarize it. First, what is the issue? Understaffing, like it does not have enough number of expertise members and less resources. Then lack of implementation, because whatever the orders it is giving, it does not have direct implementation authority. It has to give that recommendations, some other authority, some other specialized agency of the government will be implementing it. Apart from that, these decisions, these orders are not complied by the government agencies. Then whatever the judgments given by the tribunal, so they are being challenged in various courts. As a result, the time frame for the implementation is reduced. At the same time, it is excessive burden on the judiciary. Further, the role, the significance of the NGT has been reduced. Okay. So these are all some of the issues. Okay. Any doubts here so far? Yes guys. Now let us look at the way forward, that is what needs to be done so that we can have the effective implementation and to ensuring of the environmental justice. For this, NGT needs to establish principles and criteria to estimate the fines, the damages and the compensation. It has to have a codification of all this. This much of damage, this much of fine, okay, this much of compensation, and it should also identify the institutions and experts who can help it to scientifically estimate environmental damages. For example, we have environmental impact assessment, social impact assessment, the compensation that needs to be given. So for these, we can have expert members, environmentalist, ecologist, they can do the expert work and provide. If this much of loss is there, this can be done. Okay. Then, as the scale and nature of the environmental litigation has been changed drastically over the years, the government must show seriousness in appointing a variety of expert members, like different type of expert members from different fields of the environment, so that you can have that group of expert members who are from different streams of the environment, and they can provide their valuable suggestions, valuable informations, and they can give the proper judgments whenever there is an environmental issue arises. Okay, so this is another one. Then the third point is the NGT deserves more attention today, because the environmental degradation is happening at a faster rate, and it is the need of the hour that we need to strengthen NGT by giving it more resources, more staff members, expert members, at the same time more priority and legal enforcements. It has to be given legal backup. Legal backup is already there, but in terms of implementation of orders, we have to give the backup. If possible, we can give the constitutional backup. We can provide some of the constitutional provisions for NGT. Even we can be made an a constitutional body, so that it can ensure the environmental justice. In this manner, we can provide the way forward. Okay. So the other things, like government needs to provide adequate financial support, like human resources and financial resources, which I have discussed already, providing more staff members and more finances. Then other country laws like Polluter Pay Principle, we have this, but the implementation is at lower strata, you can say. Okay, it's not properly implemented. Polluter Pay Principle related to the environment should also be included within the ambit of NGT Act. The government should cooperate with it at the central, state and local level, so that it can work effectively and efficiently and ensure environmental justice. So in that manner we can conclude it. Okay. Yes, Shalu Jain, Vineet, Kundan, Pooja, Aryan. So any doubt guys? If you have any, please put it in the chat box. I will I will reply to them. Okay. Yes. Now let us go to the next question. I'll try to be little quick here. Okay. Yes. Let us go to the next question, which is, in the recent past, it has been noticed that the governors are at the behest of center rather than performing their obligations as a constitutional watchdog. In the light of this statement, has the post of the governor become dispensable in the interest of federalism as enshrined in our Constitution? So you just have to put your viewpoints. See, first let me discuss the structure. In the structure, let us first introduce related to the government role of the governor. Okay, what is the titular governor? What is his role? He is like the president in the center, the governor at the state. Okay, so what he does, he is agent of the central government, and he is an important communication channel between the center and the state. Thereby his ideal responsibility is to ensure federalism in the country. But however, there are some issues, and there has been many instances in which the role of the governor has been misused, and as a result, the person who is supposed to be a watchdog of these constitutional provisions of this federalism has become a agent in order to misuse it, in order to hamper it. So in that sense, has the role of this governor become dispensable in this present scenario? Discuss it. Okay, so that is the question, demand of the question. In the approach, let us write little bit introduction about the governor. Okay, then after that, what are the related constitutional provisions related to the governor, then explaining how the governor acts at the behest of the center, what are the provisions, okay, different types of articles, how the governor plays a role in which he does the bidding of the central government, it feels so. So some of the misusing cases and examples. Then provide some of the suggestions to make the post of the governor effective. There we can look up to the recommendations of Sarkaria Commission, Unchi Commission, then even Administrative Reforms Commission. We can look up to them for these suggestions and then measures. Then finally we will be concluding with a way forward. So that is what we are going to do. Okay. In between, is there any doubt? Okay, so far no doubts, no issue. Okay, let us go to the actual content. See, initially let us write little bit about introduction of governor. See, the governor is the constitutional head of the state, like the president in the center, and under article 155 and 156 the governors in India are being appointed by the President of India, and they hold their office during the pleasure of the President. It means the President can remove these governors at any point of time. Okay, so there is no security of tenure to the governors. So that point has become a main issue why the governors have been misused by the center many a times. Okay. So this post has been argued to be the most politicized ones and most misused one, because if you see that history, if you see many of the events, the main problem with the governor's role is the discretionary functions of the governor, they have not been explicitly said by the constitution. As a result, when the discretionary powers are not specified, there is no limit on them, then there is a huge scope for abuse, there is a huge scope for misuse. So that is the main issue which is happening with the role of governor. Apart from that, there is no special criteria for the selection of the governor. So that is, we'll look at those provisions in the due course. So now let us look at some of the instances or some of the cases or some of the provisions which say the governor is acting at the behest of the center. The first one is, while there have been exceptions to the rule, the post of governor usually goes to the party loyalist, the person who has served to the political party for a very long period of time. Okay, to those persons, or the persons who have retired as a civil servant, so who has commendable track record in the career. So such persons have been appointed as governor, lieutenant governor, or administrator of a union territory. These sort of posts have been given to them. Okay, and with a little regard to any merit or suitability. So this is what I was talking about. There is no particular qualification of a person to the post of governor which is ensured or which is prescribed by the Constitution of India. It does not put any such sort of limitations or any qualifications. That has become a biggest problem. As a result, the position of the governor has been many a times given to the party loyalist. Okay, this is decided by the central government, and on the advice tendered by the central government, the governor is appointed by the President of India. Okay, then the governor is appointed by the President and holds the office until the pleasure of the President. That means he can be removed at any point of time. As a result, what happens? That it indirectly says the President does not do this work on his own. He has to perform this job based on the advice tendered by the central government. It means indirectly the appointment as well as the removal of the governor is in the hands of whom? The central government. If the security of the tenure is in the hands of the central government, obviously me being a governor, what I'll do? I'll do the bidding of the central government. Okay, so that is another issue. Okay, central government, many governors are removed after the change of guard at the center. When there is change of government, then many of the governors are removed and some of the persons who are loyal to them, they have been put into that position in many of the states. Then Article 356, this is another important one. See, the state emergency, the precedent rule that we talk about. In the emergencies, national emergency, state emergency, financial emergency. The second one, state emergency or precedent rule we are talking about, under Article 356, it has been imposed and more than 120 times in various states, and it is at the whim of the governor. Okay, the governor recommends it, the precedent rule. Okay, so whenever there is a feeling that there is break of the administrative break and constitutional breakage in the state, the governor will recommend it. Okay, and if the state is not adhering or not complying to the guidance, the directions given by the central government, Article 365, okay, then also invoking 356, they can impose precedent rule in that particular state. So again, the governor position is used for that purpose. So that is another point we can say, the governor is acting at behest of it. Then apart from that, the post of the governor has become a matter of contention. The argument is that they are beholden to their political masters and ever willing to meddle in the state politics so as to help topple duly elected governments. What is the meaning of it? See, in the state, elections takes place, and sometimes if there is no clear majority, if there is no magic number for any particular political party, then the coalitions happen, then they try to form the government. At such positions, the role of the governor becomes very, very important. The governor has the discretion to call any of that particular party to which he feels that has the majority. He can call upon that party to form the government. So that provision has been misused in many instances. So even the party which does not have the majority, the governor can call it to form the party, and as a result there is defections. And again, the defections when happens and then government forms again, the role of the governor comes into the picture. So this is one more issue. Then recently the role of governors in some states came under the Supreme Court's scanner because of these things, like with respect to disqualifications of the members of Legislative Assembly. So that will be in the hands of the governor, okay, with the suggestion of the Election Commission. So that person will be doing it, disqualifications and all. Okay, so these are all some of the issues and things. Apart from that, there is one more issue, the constitutional one, which is related to Article 200 and 201, where the governor gives assent to the bills. So in that there is a provision, the governor can reserve a bill to consider it to the president. That is also his discretion. If he feels that so and so bill needs to be going to the president, he can reserve it and transfer it to the president. So that is one more contention point. Okay, so these are all some of the issues. If the central government gives a direction, so and so bill of the state, you reserve it for the president consideration, then the governor will do it. Okay, so that is one more point. Now, dispensing or retaining the post of the governor, whether should we dispense it, हटा देना चाहिए या इसको रिटेन करना चाहिए. अगर हटा देना चाहिए तो what are the reasons, and अगर हटा दे रहा है, so what can be done in future. अगर रिटेन कर रहा है, how can we address these measures, that we need to discuss. As far as the constitutional provisions are concerned, the governor is expected to act as a link between the communication channel between the center and states. This point I have discussed earlier. Okay, he is the very important channel through which the central government ensures good functioning in the state. He is a very important communication channel between the center and the states. So with this view, to make the federalism, like the entire Union of India, even more stronger, so that we can have cooperative federalism. That is the ideal role. So if you are to remove that post, then there will be complete breakage of this chain. Then there won't be, see, if you see, one of the salient feature of our constitution is what? We have federalism, and at the same time we have tendency towards unitary, unitary nature of center. So both the features are there. Depending upon the time, depending upon the need, the nature of the Indian federalism can change it to unitary basis. So here the governor also plays an important role in that transition. Okay, if you have to remove it, we may lose that balance. Second, the constitutional framers were very of strong centrifugal tendencies in our diverse multi-religious socio-polity, and decided to continue with this post so as to enable the union government, please highlight this, enable the union government to have its eyes and ears in the states, so that they ensure that in states the constitutional measures, the constitutional mechanism is going smooth. There is smooth functioning of the executive. The laws are made ensuring the constitutionality of them. So all of that can be ensured by whom? By the union government through the governor. So again, I am just recalling 356. If there is breakdown of the constitutional machinery in the state, administrative breakdown is there, what will happen? The governor will invoke the precedent rule. He will recommend the precedent rule. So thereby again ensuring the administration in accordance with the constitutional provisions. That is a very important role in the state, and to check the state governments from pursuing policies that may not be in conjugation with the national priorities. Like as a nation, if you wanted to develop, all the states have to perform the same, all of them have to walk on the same rope. So to ensure that unity, to ensure that uniformity, it is necessary that the governor has to play his role. So that is another important point here. Then the Indian polity is still susceptible to being pulled in all directions by the forces. The point here is very simple. We just, to ensure the democracy, the role of the governor is important, and ensuring the national unity, integrity and safety of the nation, again it becomes very important. That is the simple meaning of this point. Then the governor enjoys wide discretionary powers under Article 163, which talks about the ordinance making. Okay, sorry, this is for suggestions, like with respect to the suggestions. Then 213 is the ordinance making. Then 200 and 201, which I have discussed with respect to giving assent to the bills and then reserving the bill for the consideration of the president. These points I have covered. Okay. Then the governor seeks the report from the state government on the status of the bills, it keeps the central government informed about all the activities in the state, and sends the report regarding law and order or breakdown of it. This also I have discussed it, so that it ensures the constitutional machinery, constitutional provisions in the state. Okay. Now it ensures all the points, it indicates that the role of the governor is important. We cannot dispense it. We have to continue with the position. If we are to continue with the position and the position has issues, what measures we need to take in order to reduce these issues? Let us look at the suggestions. The first one is to make the post of the governor effective. we can go ahead with the recommendations of the Sarkaria Commission, Punchi Commission. So both of the commissions have given certain recommendations with respect to the role of the governor, the selection of the governor, the appointment of the governor, what person has to be appointed. Okay, so the manner of the appointed, same, appointed by the president on the advice of the central government. But here certain qualifications such as the criteria, he should be eminent person, okay, he should be outside the state. For example, state of Kerala might get a governor from another state, not from the same state. So thereby it ensures that at least the person is not attached with the local political parties. Okay. So that is the reason why this recommendation has been given. Then he should be detached figure. It means he should not be politically active. He should not be engaged or attached with any of the political party. Then there will be neutrality. So that is the another point that has been put by the, that has been suggested by the Sarkaria Commission. Then he should be a person who has not taken too great a part in the politics, like politically he is less active, such sort of person. And apart from that, Punchi Commission has also given certain recommendations. So other recommendations include, we can have a national panel that should be preparing after involving the opposition, ruling party, civil society, even the judiciary and other person, so that the governor should be appointed from this panel after consulting the CM of the concerned state. Why the consultation with the CM of the concerned state? So that there is smooth functioning in the state. The governor goes in consonance with the state government, the state legislature. For that purpose, we can have this consultation. Then ideally speaking, a governor should not be posted in his native state. So that is the second recommendation of the Sarkaria Commission, that the person has to be from the outside state, so that he will not be having any vested interest in this particular state. Then the arbitrary dismissal of the governor should be stopped. Like it is talking about a kind of security of tenure, so that the governor can function without any fear or favor. Fear that his position will be lost after some time, and favor can be checked by ensuring that this person is not from the native state. So these are all some of the measures that can be taken. Apart from that, the governor should not be allowed to acquire any political position, so that complete detaching from the political party. And the discretionary powers need to be, mentioned. To what extent? Like the president also has the discretionary powers, but in the constitution, the limitations of these discretionary powers has been set, well defined, well notified. In the same manner, the discretionary powers of the governor should also be mentioned explicitly. Then the misuse of this role can be reduced, can be minimized. Okay. As far the power to reserve the bills is concerned, this should be continued. Yes, because it is a good practice. It ensures the constitutionality, like Article 200 and 201 assent of the bills by the governor. Continued, but it should be resorted to in the rarest of the rare cases, like when it is exact and actual need that the bill has to go to the scrutiny of the president, then and only then it has to be reserved to the president, otherwise not. Okay. Not to persecute the state government. So that is another one. So with these points, our conclusion should be optimistic, saying that the intention behind creation of the role of the governor is to ensure a communication channel between the state and the center in order to promote the federalism. But however, the misuse of these functions, the misuse of this role of the governor has been reduced, has been put this role in contention. So we have to eliminate, we have to take care of those provisions such as the discretionary powers of the governor, security of tenure of the governor, so such sort of things, ordinance making of power of the governor, in order to ensure that this role is going to ideally fulfill the function that it has intended to. So in this manner we have to conclude it. Any doubts in this, right? Yes guys, any doubts? Okay, cool. See, here we can give many cases, many examples such as SR Bommai, okay, then Cooper's case with respect to ordinance, then Bhuta Singh case, okay, or Wadhwa case, DC Wadhwa case. We can give many of these examples, current affairs related examples, okay. So some of the cases like this SR Bommai case, okay. Now let us go to the next question, which is in the recent times. This question is important. This question can come in the examination because this is happening in the recent times. In the recent times, it has been seen that regressive laws are being used to suppress dissent and criticism. Discuss. Discuss is the keyword. Let us see. Let us look at this. The approach is same. Let us have the introduction related to what is a regressive law. Okay. Let us give some examples. Regressive law is any such law which tries to suppress the people, which tries to suppress our freedom of expression, our viewpoints, the activists, their functions, that will be suppressed by these laws. Such laws we call them as regressive laws. Then let us explain some of the draconian or regressive laws such as UAPA, Sedition Act, or Defamation, National Security, etc. Okay, and then finally we will be providing some latest facts and figures like current affairs related to the misuse of such laws. Like all these laws, if they are used in the proper way, they ensure safety, security of the nation, but there is a huge scope to misuse them. Okay, UAPA, it has been misused many a times. Okay. Similarly, NSA has also been misused many a times. Even the sedition has been misused. Many a times the PIL was there in the court, Supreme Court. Let us wind up sedition. It has the background to like a colonial period when the Britishers had made these laws, like when our freedom fighters were fighting for the freedom and they were criticizing the government. So that's why the Sedition Act came into being in order to book them and put them behind the bars. Now there is no need for it. So many of the people has gone saying that there is no need, but Supreme Court said that still the need is there in order to have the effective governance. If the government has to perform its functions, so some of the adversaries which hamper the smooth functioning of the government must be arrested, there must be such sort of law which can help the government in checking them. That's why we are still continuing with the Sedition Act. But however, these regressive laws, these draconian laws have been misused many a times. Okay, let us see those them. Let us look at the model answer and try to answer whatever the points that we have been answering, like the introduction. Yes. Okay, Pooja, no doubt. Great. So let us go ahead and understand. See guys, if you get any doubt like related to this question or any topic that we are discussing, or even a general doubt, sir, related to कुछ भी पूछो, पेपर से related, UPSC से related, okay, nothing else. UPSC से related, exam से related, pattern से related, or how to manage any of these, like earlier our friend was asking, sir, space को कैसे manage करना है और briefly कैसे express करना है और representation कैसे करना है. For example, let me take this, okay, let me I'll try to make it here how to represent, मतलब paper पे कैसे represent करना है sir. So for that I'll represent here. See, initially we will be writing introduction. Of course, this introduction, body, conclusion, we will not be putting any subheadings. It is understood. The very first paragraph is related to the introduction. Then the body, like what the points that we are writing. So all of those, the body, then conclusion by itself. However, in the way forward, our future perspective or the need of the hour, that we will specifically put the heading. Okay. So related to any of these, if you have any doubts, I am available. Just put it in the chat box. I'll reply to each and every query of yours. Okay. Yes. Now let us go and discuss this particular question. See, as I said, the introduction should be regarding these regressive laws, like how these laws are suppressing the freedom of expression, the right to life and personal liberty, equality, such sort of things. Okay. Let us look at them. Like dissent and criticism of the government are essential ingredients, because see, if you are not happy with the governance, if you are not happy with the performance of the government, you have to show the dissent, right? Then and only then the government get to know that their functioning is not accepted by the people. So for that we need to express it. The freedom of expression, speech and expression is a fundamental right under the Constitution. So when it is related to the functional aspect of the government, it becomes very, very important. Similarly, the criticism of the government, if the government is not performing well, then we have to criticize it. Of course, being a civil servant, we will always be criticizing constructively. Okay, constructive criticism. Because you are going to enter into the same system. So even if there is any problem, of course आवाज उठाना चाहिए, उस problem के बारे में बात करना चाहिए. At the same time you have to constructively give the measures. ये वाला problem है, इस पे genuine problem है, इसको check करना है, इसको कम करना है हमें. इसके लिए this is the measure that we can do. So that is how we have to represent, because we are civil servants. Okay, not the janata, not the normal persons. Okay. So here we are talking in the sense of the normal people. Dissent and criticism of the government are essential ingredients for a robust public debate or for robust democracy. This is very, very important. Okay. Yeah, for vibrant democracy it has to be there. But however, misuse of some regressive laws against such a sort of dissent and criticism, what it does? It will create fear in the minds of the people. Then they won't be able to say frankly, this is the problem that we are facing. This is the issue with this government. It has to be reduced. It has to be eliminated. They won't say it. They will fear it. That will lead to entire demolition of that particular democracy. So that is the main problem with these regressive laws. Of course, the intention behind making of these laws, you might ask, सर अगर इसमें प्रॉब्लम है तो बनाया क्यों है ऐसे लॉस? बनाने की क्या जरूरत था? जरूरत ये था, these laws have been utilized, they have been helping in checking the adversaries, in checking those persons who are becoming an obstacle to the democracy, who are spreading hatred in the society, who are spreading hatred against the government. Such लोगों को कम करने के लिए, सच लोगों को टैकल करने के लिए ये वाला रेग्रेसिव लॉस बनाया है. ठीक है. बट समटाइम्स दीज लॉस हैव बीन मिसयूज्ड. ठीक है. सो नाउ दैट इज वेयर वी हैव टू फोकस. So let us look at some of the laws which are regressive in nature, which are suppressive in nature. The first one is UAPA, Unlawful Activities Prevention Act. See, the main intention behind this act is very, very important, because it wants to reduce any kind of terrorist activities, like it is an anti-terrorism law, to prevent any sort of unlawful activities such as organized crime, abuse, drug trade, arms trade, ठीक है, kidnapping, such sort of things. In order to reduce them, in order to completely eliminate them, this act has been enacted. But however, it has been misused. That has become the biggest problem. To prevent such unlawful activities, associations, and maintain sovereignty and integrity of India. Are you getting this point? Sovereignty and integrity of the India. It empowers the Director General of National Investigation Agency NIA to grant approval of seizure or attachment of the property. If any such property is there, that can be seized if that property has any attachment with the terrorist organizations or some organizations which are adverse to the our national security and integrity. Such things can be acquired by the government. Okay. So this is a good law, but there are some instances it has been misused. We will see it later. See, this is some statistics for your information. The number of people which are booked under UAPA and what is the conviction rate there. Okay, all of it has been given. So what is the issue with it? If such cases, such instances are there and they have been booked, some of the innocent have been booked, that will suppress the their freedom of expression, their fundamental rights like Article 19 which talks about freedom of speech and expression, like 6 rights, and 21, even the 14, Article 14 which talks about rule of law. So all of them have been hampered. Okay, so that is the main issue with them. So apart from these, the National Crime Reports Bureau, this is an organization which keeps track of all the crimes, their conviction rates. It has said that the conviction rate under UAPA cases was 33.3%, like 1/3 of the cases which are booked under UAPA has been like having a conviction across the country, and earlier it was less. Okay. If you see in 2015, 14.5%, 2014, 27%. So looking at this large picture, the National Crime Reports, National Crime Records Bureau, the data it is revealed that over the half of the trials, like whatever the trials that we are getting, they are being acquitted, like they are being said that you are innocent. It indicates that many of the people who are not actually convicted, like who are not actually done anything wrong, but just because of it, just because you have UAPA and because they are raising voice or they are doing certain activity, they have been booked under UAPA and then put in the jails. When the conviction has been taken, then it is showing that they are not actually committed any crime which is amounting to their arrest under UAPA. Are you getting the point? Like their conviction is low. 1/3 conviction rate, that means 2/3 of the people, like every 2 persons in 3, they are innocent. They are just being booked under UAPA. Okay. So that is the main issue. So this is related to UAPA, Unlawful Activities Prevention Act. Now let us go to the next one, which is Sedition Act. See, section 124A of the IPC, it deals with sedition. Now let us understand what is the meaning of sedition. Sedition means any act or activity or a speech which is to like hamper or which obstructs the government or which is against the government. So such acts, such persons, they are booked under sedition. So this was a draconian law, like colonial law during the times of British Raj. Okay, it has been enacted, and many of our national leaders like Bal Gangadhar Tilak, Mahatma Gandhi, they were put behind bars because they were speaking against the government. Now you might ask, what is the need of it in the present time? The same question has been asked by many of the activists. They have filed many of the PILs, public interest litigations in the Supreme Court, saying that let us repeal Sedition Act, it has no use now. However, still in the society you can see there are some adversaries, there are some persons, there are some entities, organizations which are against the government, which try to spread hatred in the society, which tries to bring this communal disharmony in the society. To deal with such people, to deal with such organizations, we still need Sedition Act. So that is the reason why it is there, but the issue is misusing of it. In all these regressive laws, the intention behind their formation is good, that is to check any adversary persons who are hampering, who are threat to national security, national unity and integrity of the nation. But sometimes it has been misused. That has become the issue. So these points I have discussed. Okay, these are all the latest people. If you see over the years, many of the people have been booked on the sedition. Like you can see, even if there is a cartoonist, there was a case related to some cartoonist. He has put some cartoon, and that has been like said as it is amounting to sedition. That person has been arrested. Okay. So these are all some of the examples, like Assam activist Akhil Gogai, Kerala based journalist Siddiqui Kapan. So some may even climate activist Disha Ravi. So and so people have been put, arrested under Sedition Act. Now again, if you see the conviction rate in 2019 here, it's only 3.3% in 2019. It indicates that even though, suppose if 100 people have been booked under sedition, how many people are actually doing the sedition? Only 3%. Remaining 97% have been booked under sedition just to suppress their voice, their rising voice against the government for some activities. Okay. So this is the point that we have to understand. So this is all like data is saying, like not me. Okay. Next, let us see the next one, which is defamation law. So this defamation can be of two types: civil defamation, criminal defamation. Civil defamation, not a big issue, just paying of the some fine, you will be acquitted. The criminal defamation, it is the main issue. Okay. What is the meaning of defamation? Defaming somebody. Like I am some public figure, I have done some act. So if the person start saying that they start complaining on me being a public authority or being this public figure, so and so person has done this person is not doing the good act. Like what that person is doing, they are trying to defame me. Whatever the fame that I have, they are trying to defame me. So in such a cases, this defamation will occur, particularly on the civil servants. When there is like defamation, many of the people have been booked under this defamation law. Okay. So section 499 of IPC deals with it, and again the same issue, like a criminal defamation, there is imprisonment of up to 2 years is also there. Okay. So here also the intention behind this law is good, so that it ensures the smooth functioning of those personals and ensuring the individuals, like such sort of public authorities or individuals, their personal liberty and ensuring their like dignity. But when this happens, a defamation happens, there is a harm to the dignity of that person. Okay. So that is the good intention, but misuse has been done. Then apart from that, NSA, the last and important one, National Security Act. Like WAPA, it is also to ensure the national integrity and security of the nation, like national security, or prevent any person from disrupting any public order, the harmony in the public, or law and order problem, creation of the law and order problem. Such persons will be booked under NSA. So under the law, the maximum span for which a person can be detained is 12 months, okay, 1 year tak. However, the government can extend it if it feels so. A person detained under the NSA can be held for 10 days without being told the reason, of charges, on what charges that person has been booked. Okay, generally when any person is being detained, they have to, like within 24 hours have to be produced in front of the court, and they have to be duly informed what are the charges on which they have been arrested. But here there is no need up to 10 days. Okay. So this is one more issue, one more law, regressive law. Now the most recent use, like during the times of CAA, Citizenship Amendment Act of 2019, during this time also NSA has been used. If you see, using this even in some parts of Kashmir, Jammu and Kashmir, okay, still because of this NSA, many of the services have been reduced. Even the restoration of the 4G internet is not still complete there. Okay. So these are some of the issues with this, and this is the latest example like NRC and CAA. When this has happened, there was disruption because of the strikes which were going. So there was a disruption to the public order. As a result, they have invoked this NSA. Okay. Now, see, before concluding, like you were asking the representation. So introduction we have done. You will be writing introduction in some lines. Then we will be entering into the body where we will be talking about the regressive laws. Regressive laws. So here, one by one, you can give the 3 are more than enough. 3 regressive laws are more than enough. Prioritize, like you can say WAPA, and then how it is leading to suppression, how it is leading to like lack of freedom of expression. Okay. So how it has become a regressive law. Then what are the issues with it? You can provide some facts, some data, like we have seen National Crime Records Bureau data saying that the conviction rate is very, very less. It indicates that the persons are being booked under UAPA, but they have not actually committed that crime. See, apart from all of them earlier ones, there is one more thing which is a constitutional provision which is called preventive detention. Preventive detention. See, detentions is of 2 types. One is like when you have committed some crime, okay, then there will be a detention. Another one is there is like that detention we call it as punitive decision, like a punishment. There is one more detention which is preventive, like before committing a crime, there is a credible intelligence report that so and so person is going to commit a report. Then there will be like detention of that particular person in order to stop any future crime. Okay, that is called preventive detention. Now preventive detention is also a kind of regressive one. Why? The intention behind it is good, in order to stop any crime that is going to happen in the future. But many a times the people have been booked under preventive detention because here there is no clear-cut rule. Just a suspicion that this person is going to commit some crime. On that basis, that person can be put behind the bars. Okay. So this is one more example we can give. So in this manner, discuss about 2 or 3 regressive laws. After discussing about these regressive laws, what we can do? We can give the good intention behind it and the misuse of it. Now, what is the way forward? The way forward is the clear-cut codification under what circumstances these laws can be used, these laws can be utilized. The purpose behind it is simply following the purpose, like implementation of them in spirit. That is the requirement as of now. The need of the hour is that. So if that is done, then the persons who are criticizing, who are showing the dissent, will not be wrongfully booked under these regressive laws. So that will ensure that the persons will raise the voice against the government if the government is not functioning well. Thereby it ensures the vibrant democracy. So that is a win-win situation, because the people, they are holding the government accountable to their actions by raising the public debates, by raising the voice, by criticizing the government. Why did you do this? This is not this. So there are some loopholes in this. By that we can change that decisions of the government, we can influence it. And second, it leads to what? A vibrant democracy. In the long term, the government will be aware that if we do any mistakes, the people are going to raise their voice. They are going to show their dissent. The ultimate result will be there in the coming elections. Elections is one way of showing the dissent of the people. If they are not happy with the government, what will happen? They will choose for somebody, some other government, some other party, and that party will come to the ruling. This party will be going. They will send it. Okay. So this is the importance of it. So this is how you have to conclude. See the conclusion, certain laws are framed to deal with certain situations, and it is the duty of the government that these laws are used for the rightful purpose, which I was discussing, like implementation in spirit. Just implement it, use it for the rightful purposes, not misuse it. If the loopholes are there, try to fill them and do not take advantage of them so that to book innocent people. Okay? And it is also the duty of the society that if anything is misused, they need to raise a voice against it and go to the court. So if this sort of thing is there, we know clear cut, there are many misusing instances. They don't sit quietly, they will go to the court, they will seek the redressal. We have all the rights, then judiciary will do the necessary. Okay. And though some laws like UAPA is very much required, as I said, even the sedition is required, UAPA is required, National Security Act is required, all of them are required because they have certain utility, certain function to ensure the integrity, the safety and unity of our nation. But very much required in this country because there are so many seditious, secessionist and separatist, like ceding away from the Indian Union. So sort of movements are there, so sort of entities are there. In order to check them, we need these laws. But misusing of it is the issue and it has to be reduced. Then all of these laws are going to serve the purpose and at the same time they ensure like unity of the nation, security of the nation. At the same time they will also pave a way for the showing of dissent and criticism of the public towards the government whenever it is necessary. So that is how we have to end our answer. Is there any doubts in this? Okay, Pooja. Sir, if a flow chart is drawn for any particular heading like cause or significant, does it further need to be explained in paragraph? No. The answer is no, Pooja. If you have drawn a flow chart, there is no need to explain it again in the paragraph. It's a redundant one. Suppose, say I cannot draw the flow chart for the same. Like, let me take, we have one more question. Yes, Keshwan and the Bharati case, okay. We can draw flow chart on this particular question because it talks about evolution of the basic structure. So here there are steps which we can show in terms of a flow chart. For example, starting from the very first amendment like 1951 Shankari Prasad's case, from there onwards, what developments have happened, like Shankari Prasad case, then from here, what developments that have happened, like what amendments that have happened. For all of them, like Golaknath case, what is the Golaknath case? What is the judgment here? Then in return to that, in retaliation to that, in reaction to that, what amendment came? Like 24th amendment. Then again, what is that 42nd Amendment Act? Then again, how this has led to the Keshwan and the Bharati case and then development of basic structure doctrine. In this manner, we can represent in a flow chart base. Once it is represented, then there is no need to again write it in the paragraph form. You have represented it already. Okay. So the answer to your question is no, we don't have to write again in the paragraph form. So is that clear? Any other doubt? Okay, great. Now let us discuss next important question, which is Keshwan and the Bharati case shaped the future of India as a democratic republic. Discuss it. Like discuss, what is the jargon? Discuss. Discuss means charcha karna, like chai pe charcha, what we do it, like general discussion. See here, the question is pretty much direct, but it has very much applicability. Like it is saying the case has shaped the future of India, because the case is very significant for what purpose? For the evolution of the basic structure of the constitution. And this basic structure of the constitution, that is like it is ensuring the constitutionality. It is ensuring the basic features which are there in the constitution. They can never be amended. They have to be there in your constitution. And many of these features, they have been put under the basic structure, and based on that, the judiciary is ensuring that the citizens of the people, they are governed on the principles of the constitution. Otherwise, the parliament has the power to amend the constitution. We will discuss amending powers and all. Amend the constitution. Okay. In this amendment, if the government, if the ruling party has majority, like say it has the magic number like 2/3 of total strength of the house, इससे भी ज़्यादा majority है, then it can become a dictator. It can entirely change entire constitution. लेकिन वो वाला होने से किसने रोका है? It's the basic structure doctrine of the Supreme Court. So let us look at it, how this case has become, how the case has shaped the future of India, and we'll discuss about it. So same, the approach here, we will be giving a brief background about the issue, that is Keshwanand Bharati case. Then we will be writing in detail about the judgment in this particular case. Then how this doctrine of basic structure helped the Indian democracy, Indian constitution, and shape the Indian future. Then finally we will be concluding it. Okay. So Keshwanand Bharati case. Keshwanand Bharati case. So what is the case about? Like, see, it is said that in this case there is evolution of the basic structure doctrine of the constitution. So what is the meaning of basic structure doctrine? Basic structure has not been defined by the Supreme Court, though it has given that idea. It simply said that in the constitution there are certain provisions, there are certain features which are very, very basic in nature, and they are essential. They can never be removed, they can never be amended, they can never be repealed. Even amending can be done, but the essentiality, the basic idea behind it can never be changed. That has to be ensured. Amending, even if you are amending, you have to ensure that the intention behind it should be kept as it is. So that particular thing, they are calling it as basic features, basic structure of this constitution, which can never be hampered. Okay. So the evolution of it has happened in the Keshwanand Bharati case. That's why this case is also known as case that saved the Indian democracy, because during those time the parliament aggressively trying to amend the constitution. It was adding many provisions and deleting many provisions. Particularly the issue has come with the fundamental rights and the right to property. Okay. And then the Sankari Prasad's case, in which they were talking about when they were trying to acquire for the developmental projects and other things, the land and all. Then it has been like First Amendment, then it has been the rise of this issue started. From there onwards, with many cases like LIC case, then Minerva Mills case after the Keshwanand Bharati. So in many cases the same feature, like earlier the interpretations were different, and later they have taken a broader interpretation. Then there is evolution of the basic feature. Once this basic feature concept has evolved, from there onwards this has been given higher priority in ensuring the democracy of the nation. Everywhere when we talk about the constitutionality, we will apply this test whether these basic features are ensured or not. If any amendment is coming, so for example the NJAC, so that has come, National Judicial Appointment Committee. So then that particular thing has been impinging into the separation of the judiciary. We have separation of powers, separation of judiciary from the executive. Because of that, that has been struck down as null and void. Okay. So citing this basic structure of the constitution. So that is the reason why it is called as the case which saved the Indian democracy, and it has been established that Parliament cannot alter the basic structure of the constitution. Even though it has the amending power, but it can never alter this basic structure. So in this case, the case has like 13 judge constitution bench, So far it is the maximum strength. Okay, so in that by a majority the people have upheld that the basic structure can never be amended by the parliament. So let us take the amending of the constitution, like under article 368. For this we have a separate question, like the amending process of the constitution in India is a blend of flexible as well as a rigid procedure. We will discuss about it. I'll discuss all three types of amending available for the constitution. We'll see that there. Now let us look at it. Amending the constitution. See, the constitution of a country is the fundamental law of the land. It is based on this document all the laws and the governance happens. Okay, even if the elections are taking place that are in accordance with these provisions. So under some constitutions, certain parts are immune from amendments, like the rigid portions which are never amendable. So in our constitution also there are rigid portions which are coming under the basic structure of the constitution which can never be amended. So since the adoption, the debate related to the amendability of the constitution has been going, like to what extent the parliament has amending powers, to what extent, like to which provisions it can amend. Does it have all the limitations or all the unlimited power to amend it? That debate was going on, and finally the debate was put a hold or put a full stop, a period, in the Keshwananda Bharati case. So as I said, it started with the Shankari Prasad case in 1951. Okay, then the evolution has happened. Okay, the reasons for this is that they believed the initial years the apex court had reposed faith in the wisdom of the political leaders, and as a result initially they said that they can, yes, the parliament has all the amending power, it can amend to any extent. Later the Supreme Court, it has taken a reverse decision and saying that no, it does not have unlimited amending power, it has the amending power of it is limited. So there, when the Supreme Court said this, the parliament reacted. It has made 24th, 25th, 26th, 29th amendment acts, in which in this series of amendments they said that the amending power of the parliament is beyond it. Okay, beyond any judicial review, it can go to any extent. Even it can amend article 368 itself, which talks about the amendability of the constitution. Such sort of amendments have been done by the parliament. But finally in the Keshwananda Bharati case, okay, it has reiterated, Supreme Court has reiterated that yes, you may have unlimited power. The parliament can have unlimited power with respect to the amendment of the constitution, but there are some features in our constitution which cannot be amended. They have to be there in our constitution. They compose the basic structure of the constitution. They are the basic elements. They are the ideals of the constitution makers. They had this wisdom. These points has to be there in the constitution. They can never be amended. That is how the evolution of the basic structure of the constitution has come into picture. And Supreme Court said, yes, you can amend it to any extent. Parliament has unlimited amendability, but it is restricted to, or it is conditioned to what? The basic structure of the constitution. It can never be altered. So keeping the basic structure intact, you can do whatever the amendability that you wanted to do to the constitution. So that is the judgment given by that. Okay, so this is the case, judgment case in this bench. So out of this 13, in the 7-6 majority, 7 majority people, they gave the verdict that parliament should be restrained from altering the basic structure of the constitution. Okay, so this thing has came, and here one thing we have to remember, the court did not define what amounts to this basic structure, what is this basic structure, but from case to case, as the courts are interpreting the different provisions of the constitution, they have added many provisions under the basic structure. For example, free and fair elections, comes under basic structure. Fundamental rights comes under basic structure. Directive principles of state policy and fundamental rights, the balance between them comes under basic structure. The independency of the judiciary comes under basic structure. The nature, democratic nature, republic nature of the Indian state, Indian polity comes under basic structure. In this manner, it has even the speedy redressal, like speedy trials, all of that comes under basic structure. So they are like a list of topics which are given. So please kindly go through those list of topics. You can go through any of the source or even your Lakshmikant book. These all the points which are part of the basic structure have been listed out. Just remember 5, 6 so that you can write it in the examination. Okay. So how it is shaping the future of the democratic India? See, many a times, I can give one example, like there was it is like 1975, it is said as the black mark in Indian democracy, like the announcement of national emergency. Apart from that, many instances were there where this basic feature, even latest one, let us take the NJAC. When there is encroachment of the executive into the judiciary, there is ultimately striking down of NJAC. Okay, so many instances where these basic features have been threatened, which are ensuring the democracy. If they are threatened, immediately judicial review, and the court, what the courts are doing, they are striking such laws, such amendments, such provisions, such executive actions, okay, which are not in accordance with the basic structure of the constitution. So thereby it is ensuring that we have, like this example I have given, emergency in 1975. Okay, so we have this democracy, vibrant democracy. See, when our constitution was framed, many of the people criticized, this is a borrowed constitution and you have such a diversity, you are never going to survive, this constitution is going to collapse, it is not going to serve the people. Many people criticized. Look at it now, even after these many, like 70 years after we adopted that, okay, after independence, still our constitution is serving, it is striving to serve the people's aspirations. Why? Because of these features, because of self correction in our constitution, because of that amendability. Like, since this is there, that's why our constitution is able to redefine itself, modify itself according to the needs of the society. That is the reason why our constitution is called as a living document. It is a living document. It changes according to the needs of the society. Today, the need, according to the need of the society, some provision is there. Tomorrow it is not necessary, it is not needed, then immediately hata do, isko replace karo, which is the need of the society. So that is available. In doing that also, the bedrock, the foundation, the basic structure is kept constant. The foundation is there, it can never be altered. On the foundation, when we are building these the smaller units, those can be altered, okay, according to the needs of the society. So that is the reason why our constitution has been fulfilling this, has been shaping the future of democratic India. Okay, so the conclusion, simple, like what I have said, like because of this, it is able to take care of the needs of the society, and as a result it is modifying itself. In that process also, its foundation, which are basic in nature, which are essential, they have not been altered, and it is ensuring the needs of the society by modifying in itself. Is that clear, guys? So in this, any doubts? Okay, Pooja, okay sir. Excuse me, like, so let us discuss the last question of this particular test, then we will take a break. Do you guys need a break? If you need, I can give the break, or if you want me to complete this test, then take a break of like 10 minutes, then we will enter into the next test. Okay, is there a option for raising hand? No, it is not there. Okay, no issue. You can comment. If you need break, please comment. I'll give the break. Otherwise, we will discuss this question, complete this particular test, then go to the next test with a break in between. Is that okay? Great, great. Okay, let us discuss this particular question. Then with that, this test will be over. Then before taking the discussion on the next test, we will take a little bit of break. Okay. So the last question of this test is, what is the constitutional position of directive principles of state policy? How has it been interpreted by the judiciary over the years? Again, this is with respect to the judicial interpretations, but particularly keeping in mind DPSPs, directive principles of state policies. Okay. Now the same, let us look at the structure. In the introduction, what we are going to write, we will be giving a brief introduction about the directive principles of state policy. What are they? What is the genesis behind it? And what is the current position of them in our constitution? Now, what are they? These are the instructions. These are the instructions to the state. While making the laws, they have to keep in mind these instructions. So what is the genesis? What is the origin? The origin is 1935 Act, if you see. Though we have adopted from Irish Constitution, but there is this provision, instrument of instruction in 1935 Act. Okay, so there some guidelines have been given to the government. In the same manner, these guidelines have been given to the government. Okay, we can trace it to there. Then what is the current position of these directive principles of state policies in the Constitution? They are put under fourth part 4 of the Constitution. Okay, and they are from Article 36 to 51. 36 deals with the definition of the state, 37 deals with like applicability and how can we strike it down and all. Then it goes like, after that it goes till 51. Again, these directive principles of state policies have been classified into different types. Of course, the original constitution does not classify it. We have classified it for our simplicity, like Gandhian based, liberal based, so sort of socialistic based directive principles of state policies, a sort of classification. Then we will be providing the constitutional provisions of DPSP, then judicial pronouncements, okay, judicial judgments which interpreted the DPSPs over the years. Then we will be writing a conclusion. That is the definition. Okay. Yes, we will be completing the test, then we will be taking the break. Yes, what is the introduction? Here we will be writing a brief introduction about directive principles of state policy. They are taken from the Constitution of Ireland, Irish Constitution. Okay, and here B.R. Ambedkar ji, like the chairman of the drafting committee, he described these principles as the novel features. Like for the good governance, these are the essential parts. That without directive principles of state policy, the governing of this country is not easy. Okay, so they are the novel features of the Constitution. They act as guidelines for the state, and it should be taken into consideration while coming up with some new policies, new laws or anything. Now DPSPs are the reflection of preamble as the goals of social justice and economic justice, political justice, etc. are ensured. See, political justice, political equality is ensured by your fundamental rights. But whereas social and economic equality, social and economic justice is ensured by what? Directive principles of state policy. If you go through the provisions of the directive principles of state policy, you come across many of the provisions which are ensuring social and economic justice and equality. Okay, so that is the introduction. Now, what is the constitutional position of the DPSP? As I said, they are put in the part 4 of the constitution. They are from article 36 to 51. Now, 36, it defines the state. So here again you have to recall one point. Article 12 in part 3 of the constitution, with respect to fundamental rights, we have a definition of the state. The same definition of the state has been produced here itself again. 36, article 36. Now, another thing, one more important thing with respect to enforceability is, like, your part 3 fundamental rights are enforceable by the courts, justiciable, but DPSPs are not justiciable. You know this fact. What is the reason behind it? Because when we were born as a nascent stage, what was happening? We do not have enough resources. So when we do not have enough resources and there is a large diversity, huge geographical region, and we won't be able to fulfill the needs of all the peoples, and if they are made justiciable, then whenever the need has been not fulfilled, the person will go to the court and there will be a constant bickerings between the state and the court. As a result, these are not being put under justiciable. Okay. So this is the position. Then some of the articles I have given, like 39B, some amendments have been done and they have been included into the DPSP. Okay. Now having understood the position of the DPSPs in the constitution, let us look at the judicial pronouncements, judgments in this regard with respect to the interpretations of the directive principles of state policy. Okay. Like when we are comparing with, just now I just compared with respect to fundamental rights, they are justiciable, these are non-justiciable. So if they are non-justiciable, of course they have lower priority compared to the fundamental rights. So this was the earlier notation. Now earlier pronouncements. Now let us look at how the courts have been judging them, how they have been giving a pronouncements related to these things. Okay. So judicial pronouncements. Sabse first, Champagan Durai Razan case. In this, Supreme Court, it is of the view that if a law, if any particular law has in contention with the fundamental rights, it would be void. But the same is not with the DPSPs, because fundamental rights are justiciable, but DPSP is not justiciable. It means a state can make any particular law, okay, which can come in contravention, in contention with the DPSP, but not with the fundamental rights. That is the first viewpoint of the Supreme Court initially. Later, look at the Kerala Education Bill 1957 case. Here the court said that in case of conflict between the fundamental rights and DPSP, like between these two, if there is a conflict, the principle of harmonious construction should be applied. But still, after applying this doctrine of interpretation, there is a conflict between them, then the fundamental rights, the former, that is the fundamental right, that should be upheld, that should be prevailed. So here the higher priority is given to what? Fundamental rights rather than the DPSPs. The same is the case, okay. In the next case also, Venkatraman versus State of Madras case, again here the fundamental rights have been put above the DPSPs. Now coming to the Golaknath case, the court was of the view that fundamental rights cannot be curtailed by the law made by the parliament. In furtherance of this, the same court also said that if the law is made to give effect to Article 39B, just now I have given it, just look at here, Article 39B, and see they have been given supremacy. Okay. So if they have been made, any particular law is made to give effect to Article 39B and Article 39C, which come under the purview of DPSP, and in this process the law violates the Article 14 or 19 or 31. If any of these law is, if any of these fundamental rights is violated, then the law cannot be declared as unconstitutional. Simply when 39B or 39C comes, Article 49 and 19 goes, it won't work. Like 39B, in order to give effect to that, if you have made a law, then that law can be in violation of Article 14. I can give one example. We have reservation for the women. Reservation for the women, in order to ensure their representation is adequate. So this is a kind of discrimination. But what type of discrimination? It is a positive discrimination. This discrimination is done, this positive discrimination is done in order to ensure their representation, so that they are disadvantaged, they are not adequately represented, there is no equality. So by doing this, they can be brought at the equal footing with the male genders, okay, male people. So that is the reason. So here, when this has been implemented, now Article 14 is not applied. The equality rule of law, it's not applied. So there is an exception. So when 39C or 39B comes, Article 14, 19 goes. Okay. So that is the point. Then 42nd Amendment, the Constitutional Amendment, it has widened the scope of Article 31C to cover all the directive principles laid down in the Constitution. So whatever the earlier only 39B, 39C, they were constituted, but 31C, it has said that if any law made under 31C to give effect to directive principles of state policy, then even that comes in contention with the fundamental rights, but still it won't be null and void. It is not unconstitutional. That has been included here. Then Keshwan and the Bharati case, the apex court said it placed directive principles of state policy at a higher pedestal than fundamental rights. Here the more priority is given to directive principles of state policy. Later, finally after this is where your doctrine of basic structure has evolved. After that, in the Minerva and Mills case, this is very important case. In this case, what Supreme Court said is, the balance, the harmony between fundamental rights and directive principles of state policy, that is the required one, that is the need of the hour, and that is the basic structure, that is the intention behind putting these fundamental rights and directive principles of state policy by our constitutional makers. So that balance between the fundamental rights and directive principles of state policy, it is the bedrock of our constitution, okay, and they are complementary to each other, okay, they are complementary to each other. So that is the final verdict related to DPSP. So that and the same has been reiterated many a times. So please remember this particular one, very important one, Minerva Mills case one, okay, where both of them have been, the harmony between them, the complementary nature between them has been given higher pedestal, okay. Then latest one, like Unikrishnan case, the court was of the view the fundamental rights and directive principles are not exclusive to each other, therefore they should not be read in exclusion. Like the same again, there is a conformity between these two, okay. So based on that, our conclusion will be the relevance and significance of DPSPs cannot be overlooked only on the basis of its non-justiciability. Like even though they are non-justiciable, but they have played a lot of role in ensuring the social and economic justice and equality. So that is why they are almost of same importance of fundamental rights, even though these are not enforceable. So that is the point where we will be ending. Okay. So any doubts in this particular session? We have Janvi Mishra with us. Sir, why is preamble, being such an important part of the constitution, is non-justiciable? Very good question, Janvi. The answer is, earlier, see, Preamble, what is the meaning of preamble? Preamble means a pretext. Okay, whatever that is there. See, earlier if you see the constitution, original constitution, preamble was not there at the initial, like it's not the preface, it was put at the end, because after making of entire constitution, taking the points like what is there in our constitution, so summarizing those points, like what is the entire the philosophy behind the constitution, what are the kinds of like aspirations that we have for our people, so those have been summarized in our preamble. If you see, we the people of India, from there till we give it to ourselves, we enact and give it to ourselves on this particular day, till there you see in the preamble it tells us a lot of things, like it talks about what kind of polity that we have, what is the nature of it, the democratic republic one, sovereign socialist one, and it ensures like the liberty, equality, fraternity and unity, then security of the nation, and then secular nature of the nature. All of these things have been put under the preamble. Now your question is, sir, being such an important one, why it has not been made a justiciable one? Why it is non-justiciable? The answer is very, very simple. If you can link it with the reason why the DPSPs are non-justiciable, the same answer can apply it there. The reason is preamble has equality. Not only political equality, it talks about social equality, it talks about economic equality, it talks about opportunities, liberty of thought, expression, views, okay, and equality with respect to opportunities as well. Now you tell me, being a country with this much of huge diversity, such a huge geographical area, such a huge disparities, and having less resources, crunch of resources, is it possible to ensure equality in all the spheres? Political, possible. Social, say little bit difficult, but still if you can like all the people cooperate, it is possible. Economic, is that possible? So because of these reasons, because we are not able to provide these justices, provide these equality with respect to financial resources, that is the reason why this has been made non-justiciable. Had it been made justiciable, then what would happen? Like there will be enforcement, and the people, like a person who is sitting at let us say a ideal person who is not working anything, but he has to have the basic amenities and all, so that person can go up to the court saying that I am not getting anything, the state is not providing me, so I would like to file a case against the state. There will be constant cases rising up against the state, and state how far it can support, okay, because it has lack of resources. That is the main reason why, and the diversity being another reason. Okay, I hope this is clear. Janvi, any other doubts, guys? Pooja, Vineet, Aryan, Kundan, any other doubts? If no doubts, we will take a short break, like 5 minutes of break. 7 minutes, okay? 5 or 7 minutes, okay? Okay, we'll take 8 minutes. Now it is 11:52. We'll come at 12 o'clock, 8 minutes of break, and for that 1 hour, till 1 p.m. we have this class. That 1 hour we'll discuss whatever the questions that is possible in the test 2. Okay? So see you after 8 minutes. Thank you. Yes. Hello guys, am I audible? Just confirm me once. Okay. Thank you, Pooja. So let us go and discuss the second test of Marg Mains Answer Writing Program, Guidance Program. Okay. So you have already got the themes. So this test 2 is also okay. Just a second, guys. Here we have it. Pen is not working. Just a second. Okay, should have gone to this. That's the reason why there is no pen. Yeah. Okay. So sorry for the inconvenience. We are ready. There was no enabling of the editing. That's the reason why there is no pen availability. Now we are ready. Let us discuss test 2. See, the test 2 is also on polity and constitution. Okay, the themes of this test 2, the topics, the micro topics has already been given to you. So let us go and discuss the questions from this particular test. Okay, the very first question is amending procedure, which I discussed just before this test, that I am going to elaborately discuss amending procedure of the constitution. And this particular question is that the amending procedure defined in the constitution is a blend of both flexibility and rigidity. Explain. So 10 marker, 150 votes. Let us look at this. Okay, I'll try to give whatever the Vineet was talking about, like representation of the paper. I will not be taking the entire model answer. Rather, I'll be going for like I'll be going for a plain paper. Here I'll give you like representing on the plain paper and all. Okay. Okay, no issue. So let us look at it. See, first the question is talking about amending procedure of the Constitution, amendability, amending procedure of the Constitution, but it is saying that it is a blend of flexibility and rigidity. What is the meaning of flexibility? That is, with ease we can amend it. Rigidity, it's not being that easy. It's very rigid. It's a kind of a complete inertial one which is not changing. So let us look at what are the provisions with respect to amendment in the Constitution which are flexible, which are rigid. So then we can say, if we have the amalgamation of both flexible features and rigid features, then we can say it is the blend of flexibility and rigidity. Is that clear? Now before entering into it, our introduction is, we will be writing a brief introduction about what is the meaning of amendment. What is the meaning of amendment? Amendment of a constitution. It means simply changing provisions of it in accordance to the needs, in according to the demand of the society, aspirations of the people. We will be changing the provisions of the constitution, which is known as amendment procedure. So with that introduction, we will enter into it. In the Constitution of India, the constitution makers, they were having a future perspective. They kind of anticipated that our constitution should be a kind of document which can be changed. So they had this idea, because the aspirations of the people has to be taken care. So that's why they have this futuristic kind of vision, and they have made such a provision that this document, this fundamental law of the land, can be changed in accordance with the needs of the society. As the generations are passing by, there will be certain needs, there will be certain changes which needs to be incorporated into this fundamental law. For this purpose, they have made the provisions for amendment. Those provisions, they come under Article 368 of the Constitution. So under Article 368, the provisions of the Constitution can be amended so that we can take care of the needs of the coming generations, needs of the present generations. So just imagine how futuristic those constitution makers were, how long-term vision they had. So because of their long-term vision, we still have these provisions, and as a result of this, our document has become a living entity, a kind of the self-adapting one. Okay, so let us look at what are the flexible provisions and what are the rigid provisions in this particular amendment. So if we can take care of this, both of them, if we can discuss about both of them, then the entire answer is done, then we can go ahead. So Vineet, this is particularly to you. You asked specifically on white paper, how can we represent, sir? This is how we can represent it. Initially, the introduction, we can write a little bit about the amendment. So amendment, what is it? It is the change. It is the change in the provisions of the Constitution. That is called amendment to the Constitution. So with that, we give some basic introduction, and we say the constitutional makers, they had this futuristic view, they had this long-term view that the coming generations will be needing changes in the document. As a result, they have ensured the amendability of the Constitution by incorporating an article, which is Article 368. That will be our introduction. Now, to take care of the body, that is, our Constitution is a blend of flexibility and rigidity. Let us now handle it. So under Article 368, we have amendments. Now, outside the purview of amendment, outside the purview of Article 368 also, we have certain amendments. Like this is within the Article 368, and in the same manner, this amendability can be done outside the purview of Article 368. Now let us discuss the three ways of amending the constitution. Then we will see which one is flexible one, which one is a rigid one, and how this has become a blend of both. Is that clear? Now, see, the constitution can be amended in three ways. Okay, the first way is, of course, who can amend it? The parliament can amend it. Okay, this has been taken care by the constitutional makers, and they have now inserted this article 368, which specifies that parliament, at sometimes parliament plus ratification of the states can amend the constitution. We'll see all of them. So in here, the constitution can be amended by the parliament in three ways. The first method is called by the way of simple majority. Okay, I'll discuss what is the meaning of simple majority, do not worry. Then there is a second method, that is by the way of special majority. Then the third way is by the special majority by the parliament. Okay, parliament has to pass it by the special majority, plus at least 50% of the states, whatever the number of states that we have, in that at least 50% of the states, if they ratify it, simply endorse, ratify means simply passing it. So if they ratify it, then we can have certain provisions of the constitution amended. So these are the three provisions that we have for the amendment of the constitution. Now let us look at each and every one of them, try to understand them. The first one is simple majority. So what is the meaning of simple majority? It means in the house, we have two houses in the parliament, Lok Sabha and Rajya Sabha, lower house and upper house. Okay, so in that, all the members that are present on a particular day, present and voting. Okay, in this, if the majority of the people are asking for the amendment, then that particular one we call it as simple majority based amendment. So simple majority means in this particular classroom, let us say this is a house, though the maximum strength is much higher, but today only 50 students are sitting. In these 50 students, what is the majority? Majority is 50% plus 1. So that is 26. If 26 people say they are in favor of something, let us say in favor or against, then accordingly we will be making the amendment. Alright. So here the simple majority means the number of people who are present in a particular house, okay, and voting in the process. In that, if the majority is there, then we call that as simple majority. That has to be done in both the houses. So there are some provisions in the constitution which can be amended by the simple majority. Okay. So for example, the schedule, 5th schedule, 6th schedule. Okay. And the allocation of the seats. So, and 8th schedule, that is languages. So such sort of things, like the provisions of the constitution which can be amended by the simple majority process. So these are some of them. Now coming to the special majority. Special majority means there are two things in it. Number one, in the house, whatever the members that are present, in that at least 2/3 of the members has to vote in favor of it. So the members present and voting, in that you should get 2/3 majority. For example, if you have 150 members in the house, so out of which at least 100 members has to vote in favor. 2/3 of the majority, 2/3 of the people who are sitting and present in the voting, participating in the voting, plus in the entire house entire strength of the house, it has to be a majority one. Suppose say the entire strength is 200. Then what is the majority here? 100 plus 1, that is 101. Okay, 101 is the 100 plus 1, that is the majority. Now, in a particular house which has maximum strength of 200, in that, suppose say that particular day only 150 members are present. 150 members are present. Then, in order to have 2/3 majority, it should be 100 plus 1. 100 2/3 and present and voting. That is what your 2/3. So more than 2/3. 100 plus 1, 101. Now this 101, is it more than that of the majority of the 200? Yes, because 200 50% is 100 plus 1, 101. So this is satisfying both the conditions. If this is happening, we say the particular bill, the particular amendment has been passed by 2/3 majority of present and voting and overall majority of the house. Such a majority we call it as special majority. So many of the provisions such as fundamental rights, directive principles of state policy, etc., they are coming under special majority. Special majority. See, compared to this process, this is complex. This is little bit difficult. See here, you can do like article 2 and 3. They can be amended simply by simple majority. So here, the same example I am taking 200. Here, out of 200, that particular day, only 70 people are present in the house. Only 70 people are present in the house. So out of the 70 people, how many people's consent is required? How many people strength is required? Only 50% of this present, that is 35 plus 1. So even if 36 members are present and voting for the passing of it, okay, out of the 70, then we say it has been passed by the simple majority. But here, is it possible? No, here if 36 members are putting the vote, then it is not absolutely with the majority of the number of people. Even though let us say I'll take the same example. 70 people are present, out of which 50 people said okay, we'll go with it. So obviously 50 is more than 2/3, क्योंकि 2/3 का कितना आएगा? ठीक है, it will be close to, let me take number 90, then the calculations will be easy. So if you are taking 90, 2/3 will be 60. Suppose in that case we have 70 members saying yes, we will vote for it. So 90 members present. So 90 members present here, how much you required? Only 46 you required. But here, even if 70 members are saying okay, out of 90. So it is satisfying this 2/3 condition, like 70 members satisfying 2/3 condition. But is it satisfying? Is it satisfying the actual strength which is 200? Which is 200? No, it is not satisfying. Okay, sorry for the inconvenience. So that means out of 200, 90 members are present in the house. So present members जितने लोग अटेंड किया है उसमें 70 लोग वोट किया है हाँ पे, रिमेनिंग 20 पीपल ना पे वोट किया है. नाउ 70 पीपल सेड ओके, दैट मीन्स 2/3 ऑफ द मेजॉरिटी हैज कम. इवन इफ यू सी जितने लोग प्रेजेंट है उसमें भी मेजॉरिटी है ये, क्योंकि 90 लोग हैं उसमें 70 पीपल मीन्स मेजॉरिटी है. बट टू द टोटल हाउस स्ट्रेंथ विच इज 200, उसमें देखेंगे व्हाट इज द मेजॉरिटी दैट वी नीड 101, बट कितना आया है 70. तो तब पास होगा क्या? नहीं होगा. इसीलिए ये थोड़ा कॉम्प्लेक्स प्रोसीजर है कंपेयर टू द सिंपल मेजॉरिटी. ठीक है, फॉर दिस more number people have to be present, they have to vote in favor, then and only then it is possible. Now there is one more kind of amendability, that is Special majority, that means whatever the majority that we have discussed here, same, okay. Special majority, okay, plus ratification by at least 50% of the states. Suppose if we have 20 states, then out of 20 at least 10 states have to say yes, we are happy with it, we are also ratifying it, we are also passing it. By simple majority, whatever the majority, if they pass, even by simple majority, that's okay. We just need 50% of the states. If the 50% of the states have not passed, then that particular amendment will never come into force. Is that okay? So even after having this special majority in the parliament, still if the 50% of the states are not passed it, then it will not come into effect till that 50% reaches. And there is no time frame. Okay. So that's why this is even further difficult one. Further difficult. Now, by comparing these three processes, you can see, actually feel. The first process, which is simple majority, is there any difficulty in amending it? No. You don't have to have maximum strength. So jitna bhi, whatever the strength of the house, if you talk in actual cent, what is this strength of the Lok Sabha? 545. That is the present strength, like maximum strength. Similarly 250 for Rajya Sabha. So in this, even we need at least quorum, like 55 members needed, 10% of the actual strength of the entire strength of the house, that is called quorum. Then and only then the house proceedings will happen. So out of 545 members, even if 60 members are sitting in this house, then proceedings can happen. Further, out of this 60, even if 31 members say yes, we want this amendment to happen, then whatever the provisions which can be amended by the simple majority can be changed in the constitution. देखो सिर्फ 31 लोग से काम हो रहा है, इतना simple. And only some provisions, not to the all of them. And one important fact here, prelims के लिए बहुत important fact है, such an amendment, simple amendment, it does not come under the purview of Article 368. It is outside Article 368. That is the reason why I did not put an arrow mark under Article 368, rather I have put it a separate arrow. ठीक है? So this is one type of amendability which is very simple, which makes these provisions very flexible. So that's why this kind of amendment, it comes under flexible mode of amendment, flexibility of amendability of the constitution. Now coming to the other two, if you look at here, these two, the rigidity, like the difficulty with respect to amendment, it increases. Here it is difficult, okay, when compared to here, here it is even more difficult, because here not only there is no special majority of the parliament, but the ratification of the states is also required. Further, you have to remember, when I am talking about special majority, I am not talking about only in one house, not only in the Lok Sabha, both the houses. A particular amendment for any of the provisions that are there in here, like it may be fundamental rights, directive principles of state policy, or the issues which are related with the federal concept, like federalism se related, like the role of the president, election of the president. So all these things, even High Court, Supreme Court, these things, if there is any kind of amendment needed in their provisions, we need the ratification of the states as well. So look at here, the process became very complex. The bill has to be introduced in the house and it has to be passed with a special majority, that is majority of the total house. It has to be taken care, and जितने भी लोग present है and voting है, उनमें से 2/3 of the people has to vote in favor. So combined together, if both the conditions are satisfied, then we say in this particular house, this amendment has been passed by the special majority. Then the same bill will be sent to another house. The same process has to happen in the another house. So there, once both of the houses passes by the special majority, then it will be given to the president. And president has to give the assent. Earlier restriction was there, like he can give or he cannot give, but it has been made obligatory, it has been made binding on the president to give assent to all the constitutional amendment bills. Okay, so that is with respect to special majority wala amendment. Now if we go to the federal features of the constitution, they can only be amended with special majority in both the houses plus ratification of 50% of the states or more than that. Then and only then it can be amended. So look at the complexity of the amending process as we are going from here to here. So that is why these two come under the purview of Article 368 and they are portion of what? They show the rigidity in the amendment of the constitution. So that is the reason why we say our constitutional amendment procedure is a blend of flexibility, because very easily we can amend certain provisions of the constitution, as well as rigidity, because some of the other provisions they cannot be amended easily. Further, if you consider the basic structure wala part, वहाँ पर कुछ provisions ऐसे हैं which cannot be amended, like they cannot be altered because of the basic structure. See, the nature of the constitution, it says that India is a republic country. So no amendment can make India from republic to monarch. Okay, it can never be changed. That is completely rigid. ठीक है, समझ में आ रहा है ना वो वाला? So that is completely rigid. That is the reason why amendability of the constitution is a flexible plus rigid one. Okay, I hope this is clear. Is there any doubt in this? The same thing has been written here. Okay, the first thing, brief introduction about what is the meaning of amendment. Okay, so it comes under Article 368 Part 20 of the Constitution. Okay, the Parliament has the power to amend it. Okay, then it provides a mix of flexible and rigid provisions. Flexibility is with respect to the majority driven, that is outside the scope of Article 368 as I discussed. Okay, here see, it is just done with a simple majority, which is the outside scope of Article 368. The examples are Article 2 and Article 3. Okay. Then use of official languages, abolition of legislative councils in a state or creation of them, and altering the boundary areas related to Article 2 and 3. Okay. Citizenship. Okay. Even elections to the parliament and the state legislature, delimitation of the constitutions, and scheduled tribal areas, 5th and 6th schedule, all of them comes under simple majority. Okay, they are all amendments outside the scope of Article 368. Now coming to the rigid portion, we have two types of amendments, like special majority. I have discussed what it is. Examples include fundamental rights and directive principles of state policy, so on and so forth. Then special majority of the parliament plus consent of the state, like at least 50% of the states have to ratify it. So that is the more complex one. Under this, some of the examples are election procedure to the president, like all the things which are related to the federal, like in which both center and states are involved. So such features come under this category. Okay, the 7th schedule, which talks about like the division of powers. Okay, and Supreme Court, High Court, then GST, so on and so forth. Okay, then the conclusion. So because of these reasons, we say that our constitutional amendability is a blend of flexibility as well as rigidity, and that is one of the novel features of our constitution. Okay, is that clear? So the representation, you can see I made it little bit clumsy here, we can make it even better in the paper. Okay, to explain it I have taken the examples and all, that's why it has become a clumsier one. So in this manner also, like it's a kind of flow chart, like amendability you have written, then what is the article, that is article 368 under part 20 of the constitution. Now outside the scope of article 368 we have simple majority based amendability, which is flexible in nature, then these two which are rigid in nature. Okay, so this is how we can represent it. So in this, is there any doubt? Is there any doubt in this? Now let us go to the next question, which is examine the role played by the National Commission for Minorities in safeguarding the rights of minorities in India. So again here the structure will be very simple, we will keep it very simple. First let us write about minorities in India. What are minorities? What are the constitutional provisions that are available for them? Okay, and then we will write little bit about National Commission for Minorities and its functioning, what are the problems it is facing, okay, in safeguarding the rights of minorities. So brief introduction about National Minorities Commission and definition of the minorities. Please remember one thing, the constitution used the word minority, but it has not defined it. See, if you see article 29 and 30, it talks about rights for the minorities. Here we have two types of minorities. Okay, one is with respect to religion, religious minorities. Central government has identified them. For example, Islam, Christianity, Buddhism, Jainism, Parsis, they are all regarded as minorities in India. Okay, now apart from that religious minorities, we have linguistic minorities. Based on the language we have minorities. So that identification of linguistic minorities has been given to the respective states. In a particular state, the state can decide what is the minority with respect to the language. Okay, then we will be talking about the role and functions of National Minority Commission so that how it is safeguarding the rights of the minorities, and what are the challenges and issues faced by it, how can we tackle them, what is the way forward it. So that is the structure of it. Okay, now yes, let us see the introduction. National Minorities Commission of India, it is a statutory body. What is the meaning of statutory body? It means a body, an organization which is established by the law of the Parliament. Parliament has enacted a law. According to the features of the law, such a body has been established. All such bodies we call it as statutory bodies. Okay, now there is another term called constitutional bodies. So if any organization which has been established in accordance with the provisions of the constitution, we say that constitutional body. So that is the difference. So statutory body set up under the National Commission for Minorities Act 1992. This is the act on which, based on which we have established National Commission for Minorities. Okay, so that is the reason why we are calling it as a statutory body. It is mandated to protect the rights of the religious minorities in India. You might be asking, sir, why not linguistic minorities? Linguistic minorities is not recognized at the central level. It has been given to the states. You decide, because if you see, India has large diversity with respect to the languages that we speak. Even if you are like traveling, so for every now and then there is a change of the language. At least the dialect will change, the accent will change. Okay, so as a result of it, the minorities with respect to language is not been identified at the central level. It has been given to the states. Only the religious minorities, based on their number of people, like Hindus is a majorities in India. Apart from that, Islam, Christians, Buddhist, Jains, Parsis, all of them are what? They are minorities because their numbers are less. Okay, religious minorities. Now, definition of minorities in India. As I said, Constitution used the word minority, but it never defined. It has not defined. See, however, the term minority itself is not defined in the Constitution itself. So, in Article 29 and 30, which talks about the rights, fundamental rights to the minorities to establish their educational institutions. Okay, so they say about minorities, but they did not define the word minority. Now, currently, the linguistic minorities are identified on the state-wise. This point I have explained, because in the local languages change and we cannot have this distinction at the central level. Okay, yes. Now, let us look at some of the functions of National Commission for Minorities. So, looking at these functions, then we will look at what are the challenges and what can be done in order to reduce them and what is the way forward for it. Okay. So, the role and functions of National Commission for Minorities in order to safeguard the rights of the minorities. It is the forum for appeal to safeguard the rights and interest of minorities. Okay, it has some functions. Let us look at them. To evaluate the progress of the development, like the development of the minorities, it has been evaluated by the National Commission for Minorities, and those minorities which are not adequately represented, which are underdeveloped, they will be given some relief. They will be given some incentives. There will be some dedicated schemes. I can give one example. For the development of Muslims, for the development of Islam, like this minority, there are many schemes. One of such schemes is Nai Manjil scheme, Nai Roshni scheme. So such sort of schemes. Okay, and for Parsis I can give, because the populations of the Parsis in India is particularly declining. Then the government has come up with what? Geo-Parsi scheme. Okay, Geo-Parsi scheme. So these are all some of the contemporary examples that I can give. Then second, to monitor the working of safeguards provided in the Constitution, like Article 29 and 30. Apart from that, even the article from 25 to 28, which deals with religious rights. Religious rights. These minorities have their own religions. Okay, even the Sikhs have their own religions, the Parsis have their own religion, the Christians have their own religion. So for the protection and propagation of this religion, the rights have been included in the fundamental rights section. Okay, so how effectively they have been safeguarded, how they are working, it will be monitored by it. Then to make recommendations for effective implementation of safeguards for the protection of minorities and their interests. So this is another function. Then to look into and take up and specific complaints regarding the deprivation of the rights and safeguards of the minorities. If there is any issue, if there is any deprivation, then the National Commission for Minorities can take up the issue, take up the case, and it can investigate with the help of other organizations, and it can give the directions or recommendations how to alleviate it. Then to get problems of discrimination against minorities studied, what type of discrimination is there on the minorities, how can we reduce it, what is the root cause behind these discriminations, that will be studied in order to reduce them, in order to remove them. Okay, in order to remove them. Now, to conduct studies, research and analysis on the socio-economic status and their educational development. Okay, so what is the position with respect to their education, how many people are attaining till the higher education, and what is their socio-economic status, all of that will be researched and analyzed. Then to suggest appropriate measures in respect of any minority to be undertaken by the central or state government. Like if the central or state government coming up with any particular scheme or a policy, it will suggest how it can be made even more impactful. Then to make periodic or special reports to the center or any matter concerning the minorities, especially with respect to their difficulties, with respect to their problems, what are they faced by the minorities, those will be compiled and will be given a report to the center and respective state governments so that they can make some new policies or schemes for reducing them. To take up any other matter that may be referred to it by the central government. If the central government gives any kind of work to the Minorities Commission in order to these, like for in respect of this, do this work or do that work, that will be taken up by the National Commission for Minorities. So these are all the functions. Now, if you look at all the functions, all of them are what? For safeguarding the rights and their interest. Okay. And the propagation of their religion हो सकता है, or for their language or their script or anything related to the minorities, so that community can be preserved, conserved, and it can be passed on to the next generations. So that is the main focus here. Okay. Now there are some challenges faced by the National Commission for Minorities. What are they? With respect to capacity. That is with respect to the number of people, the staffing, the human resources and financial resources. Both of them are less. So that is the main reason. Okay. Institutional challenges for this is related to capacity to perform its functions. You have so many roles, so many functions. In order to perform them, you must have enough adequate number of human resources as well as financial resources. So that is the one issue. Then the commission is unable to effectively fulfill its mandate when the key position of the commission members remain unstaffed. This is what I was talking about. There is a crunch with respect to human resources. When human resources are not available, how can it perform the functions which are given to it? There is no effective implementation. So there is one problem with respect to the composition and number of people available. Then the lack of case processing capacity is further aggravated by lack of integration of minority commission in the states. Like you have national level minority commissions, but there is no state level minority commission in order to communicate with it, because religious minorities, they are defined in the central level, but language based minority state wise selection. So unless and until a particular state minority commission gives you the information, how can that will be taken up by a national commission for minorities? So that is another issue. Okay. Then another barrier is underutilization of the technological capacity. Like whatever the technology that we have, we are not able to utilize it to the fullest extent. So it is still rather basic software which does not by itself facilitate an end-to-end complaint handling mechanism. So this is all related to the using of technology, existing technology utilization and its integration for taking care of these issues. Then financial and expenditure related challenges I have explained. Please try to trim the information. Here there is huge information. It is 10 marks question. Try to reduce the information. You can write entire thing in one pointer. Like there is a huge financial resource crunch as well as human resource crunch, and expenditure related challenges are there. Okay. In that manner you can reduce the information. Then legal and constitutional authority related changes. What is the meaning of it? Though it has been established by a act of the parliament, but still there are some loopholes in the legal enforceability of whatever the functions that are done by the National Commission for Minorities. Apart from that, there is no constitutional identity, there is no constitutional provisions, there is no place for National Commission for Minorities in the Constitution. So giving it by amending the Constitution, providing some features into the Constitution, that will definitely strengthen the position of the National Commission for Minorities, and it can work better. When you have the constitutional status, there won't be any financial crunch because the funds are coming, okay, and you can take care of the function smoothly. So So that is another thing. So for that, what we need to do so that we can ensure the better functioning of the National Commission for Minorities, which will ensure in protection and safeguarding the interest and rights of the minorities. So what are the way forward? The first is staffing need assessment, like what are the needs of human resources that are required at present at regular interval. Look at the responsibility of the function, how much burden is there, how much work is there. So depending upon it, recruit new staffs and recruit new members, try to increase the number of members in the National Commission for Minorities so that the workload will be less and it can perform better. Then setting baseline target to keep pendency in check, so that like when this one of the functions of this commission is to what? It is to take up the cases and investigate into them and recommend whatever the compensation or the judgments. So for that, it has to keep one deadline. Like if you have taken up a case, within this deadline it has to be disposed of. Otherwise what will happen? The pendency of the cases increases, then there will be delaying of the justice to the minorities. There will be victimization of the minorities. Then technological upgrade, like we have seen, like there has been a ceiling in the use of the technology in this particular commission. So if we can upgrade the technology, if we can upgrade these software tools so that we can get real-time data with respect to the number of minorities and their extent, their geographical distribution, the kind of problems that they are facing, then it will be able to deliver better. Then expanding the legal and constitutional authority of NCMs. This I have discussed by providing the large base with respect to the legal provisions and also ensuring constitutional provisions, giving a constitutional status to it, because in India we have considerable amount of minorities, and these minorities in the majority, they might lose their identity if you are not preserving them, and the constitution has certain provisions for their like preservation, like article 25 to 28, 29 and 30. So in order to give effectiveness to these provisions, we need to have a constitutional body to ensure its effective implementation. That's why we must try to give constitutional status to the National Commission of Minorities. Then outcome based performance measure, that is which is focusing on the output, like whether we are getting the results or not on that basis. Then expanding the role of state minority commissions, like in many of the states even the commission has not been mooted. So it has to be established and it has to be expanded its functions and it has to be integrated with the National Minority Commission. Then there will be good functioning and there will be effective measures in ensuring the safeguards and interests of the minorities. Okay. So that is all about National Commission for Minorities. That is how we can ensure the protection and safeguarding of the minorities. In this, is there any doubt? Okay, if no doubt, we'll go to the next session, next question. Okay, and this will be last question for today, because I have been taking 4 hours of session. I do need break and I have another session somewhere else. So we'll discuss this particular question in detail, then we will wind it up. Okay, the question is local reservation in private sector jobs. It is a contemporary question. Many states have been implementing this local reservation, particularly in the private sector. Okay. So private sector jobs is a setback instead of providing helping hand to the thriving private enterprise of the states. evaluate. Simply it is saying, it is asking, nowadays many of the states, they have been incorporating this local reservation, like son of the soils concept, okay, regionalism concept to the local people. We will be giving reservation to the local people. So as a result of it, in the private sector particularly, instead of helping the thriving of the private sector, it is becoming a obstacle. It is stopping them. Evaluate it. So that is the question. Now, the first introduction, let us give what is the meaning of this concept of local representation, local reservation. So this has link with your regionalism. So the topic simply, it is like a under the ambit of the concept of sons of the soil, like local people. So why this sort of tendency is increasing in many states? What are the positives and negatives? How they are going to help the private sector, and how they are going to reduce the increase or the growth of the private sector. That is what we are going to analyze. That is what we are going to evaluate. At the end we will be concluding it. So that is the structure of it. We will be looking at the arguments in favor of private reservation in the private sector jobs, local reservation, and the arguments against it. Okay, why it is going to hamper the growth of the private sector, those things. Is that clear? So let us go ahead and learn. See, reservation in India is about reserving the access to particular seats or particular jobs to particular community or particular locality. So here we are talking about local reservation. That means in the private sector jobs, say a certain percentage of it has been, it has been set aside particularly for the people who are living in this particular region, in this particular state. So that is called local reservation. Okay. So in the recent times, many states, take it from like Karnataka, Andhra Pradesh, okay, Haryana, many of the states, they are coming up with, even Maharashtra at some point of time when there was a large influx of migrants from Bihar and UP to Maharashtra, they have taken such sort of measures. Okay. The same is the case with the present Karnataka. There is a huge influx of migrants in search of better living opportunities, and as a result the competition for the locals is increasing and they are not able to get the jobs, and the government has taken this decision. Let us look at both the positive points and negative points. Before that, let us look at the increasing trend with respect to this local reservation. See, look at this local candidates bill of 2020 of Haryana government. The government of Haryana, it has provided 75% of the reservation in the private sector to the local people, that is only from the state of Haryana. Similarly, the Karnataka, Gujarat, Maharashtra, Andhra Pradesh, all of them, they are coming up with such local reservations. So this trend is increasing day by day. So now the evaluation of this particular one, which is this trend is good or bad, particularly for the growth of the private sector. Let us look at the arguments which are in favor of this local representation, local reservation in the private sector, and the arguments which are against it. Okay. So in this, not only Karnataka, Jharkhand as well as UP, many states, they are coming with local reservation in the private sector jobs. Now what are the arguments in favor of having a local reservation in the private sector jobs? The first and very most important one is the migrants issue. The migrants are coming to different states, particularly from poor states to like the states which have good economic opportunities. They are moving there. As a result, when the migrants comes, many problems, like it may be the problem with respect to basic amenities, the stress, the pressure on the resources, development of the slums, I should say, growth of the slums, more and more number of slums. Okay. So they are coming, and all of them, they will lead to law and order problem as well. Okay. So that is the reason why many of the states, in order to reduce or in order to discourage influx of the migrants, they are putting more and more restrictions by giving local reservations. Okay, so that is the one thing. Okay, then the competition, because when these migrants are coming, they are going to compete with the local people. As a result, local people are not getting enough opportunities. Okay, that is another point. Then huge unemployment rate. When there is high competition, particularly for the locals, they are not able to get the jobs, the unemployment rate in that particular state increases. It means the state is producing the enough number of jobs, at least in the private sector, but those jobs are not going to the local people, rather somebody from the other state are coming and taking up that job. As a result, the local people are having stress with respect to resources. Okay, and the unemployment rate in that particular local states is increasing. So that is the another problem. Particularly during the times of this COVID pandemic, many of the people, they have lost their jobs and they are looking for these opportunities. And these opportunities, if they are taken out by some other migrants, the non-locals, then the local people has to look for other opportunities outside, even though after having good number of opportunities in their particular state. Then this point I have already explained, proliferation of slums or expanding of the slums. If more and more migrant people are coming, it will lead to increased number of slums, but because of the local reservation, the migrants can be discouraged. They won't be coming because they are not getting, like only 25% is left, 75% is for the local people. Then the influx will reduce. As a result, the proliferation of the slums will reduce. Then reduced absenteeism and enhanced efficiency. So please understand this. If we have employees from different states, which is not the local one, suppose say in here we have employees from different states, and whenever they have to travel or when they have some other works, election duties or anything, they have to go to their home state and come back. It will take a lot of time. Okay, so during that time there will be lot of absenteeism will be there. As a result, the private entity, the organization's efficiency will reduce. So in order to discourage it, in order to encourage the efficiency, in order to reduce the absenteeism, if we can give more number of jobs to the local peoples who are available readily, who are present in the vicinity, so they can present at all the times and there will be good efficiency. That is one more point in favor of having a local reservation. Then the private sector must share the burden. So what is the meaning of it? Since the private industries use public infrastructure as well as avail various initiatives and incentives given by the local states, then they have the obligation to produce enough number of jobs for the locals, so that the employment of the locals increases and they pay taxes, and that taxes will be going to the state, the local state, and revenue increases. That money again they can invest in the social sector, and that social sector can again be utilized by the private organizations. So they have the burden, they have the share in that local development. Okay, so that is the reason. Okay, this is another thing. Okay, next, these are all the points in favor of having local reservation. Now let us look at some of the points which are against why we should not have local reservation. So what are the arguments against local reservation in the private sector jobs? सबसे first, it violates the constitutional provision. Constitution, please recall Article 15, Article 16, both of them says there should not be any discrimination based on the place of birth or place of residence where you are residing, where you have born. On that basis there should not be any discrimination. So this local reservation is kind of discrimination in the employment, in the public opportunities, I should not say public, private opportunities based on your place of birth. Whether you are the citizen of this particular state or domicile of this, or you can say the local of this particular state or not. Based on that, it has been discriminated. So it is against like 14, 15 and 19(1), which is talks about, see, the occupation. Okay? Any profession or occupation according to Article 19(1)(g) of the Constitution. Okay? So that has been violated, since there is a reservation which is prohibiting you, which is stopping you from taking that particular one. Next, rises cost of compliance for the employer. What is the meaning of it? Such decisions will bring complexity and unnecessary intervention of the government employees into the private sector, since the government employees have to monitor whether the 75% of the local reservation has been implemented by the states or not, by the private entities or not. So there is infringement, there is involvement of it. So this will be raising the compliance. Then there is a fair chance that designated officers might resort to directing the organization to train the local candidates, so that local candidates can be inducted into the organization. You train them. If you are looking for some talent, you are looking for some people who are to serve in your organization. So you train our local people. After training, like give the internship or so, after training you can take them. So then they will be meeting your standards. So sort of pressure can be put on them. Okay. So this is another point in against of the local reservation. Then distortion in the labor market. So of course it happens, because see, when we do not have any restriction with respect to the reservation, then the appointment can be done based on the merit. Since now you have the restriction 75% of the reservation to the locals, even if the locals are not equipped, they are not meritorious, still you have to give it to them. Then it will reduce the efficiency of the industry. It will reduce the efficiency. Then negative impact on the foreign direct investment. Since such things are there, then the foreign companies which are trying to establish in India, they'll also be having the same rules, but they wanted to employ their employees from certain countries or certain states and certain other locations, because they want the best. Okay. If this restriction is there, then that might discourage them, and there will be lack of this FDI. The FDI will be reduced. There will be a negative impact. Again, impact on unity in diversity. Again, because it is only promoting a particular locality's populations. So there will be this impact. So these are all the negative points. Now looking at these negative points, this point I have already discussed because it is unconstitutional. 15 and 16, linking with that, we have discussed it. So taking all these points, so you have to take a balanced conclusion. Like, look at the conclusion here. India's federal government has emphasized the need to integrate India into a single unified market. In this sense, we are taking many of the initiatives. Let us say e-NAM is there. Okay, we are trying to integrate the market. We have GST, which talks about one nation, one tax, one indirect tax. Similarly, we have many things. One nation, one ration card. Okay, one nation mobility card, fast tag. So many things we are bringing in order to integrate the nation, in order to integrate all the states into one unified nation. In such a case, if these sort of things happen, then what will happen? It will be against the spirit of that federal government. Apart from that, see, integration of the GST, the recent farm laws, all of them are why we are doing it, in order to have that unification, integration. So in the same spirit, the trend towards rolling out regional employment quota compliance works against this trend, and it might lead to, it will introduce market distortions. Local reservation will severely hamper the regional industrial development, because, as I said, because of this reservation, now the industry has to take the local people irrespective of their merit. Even if they are not getting the people which are meritorious, which are satisfying their needs, still they have to induct this, still they have to employ them. Okay. So that's the reason why there will be lack of development in the industry. If you go to the question and see, the question is also saying the same. It will be what? Instead of providing a helping hand, it will be what? It will be a setback for the development of private enterprises. So that is what we are discussing. So in this manner we are going to conclude it. Okay. So this is all about for today's discussion. I hope you enjoyed the session. If you have any doubts, please comment. I'll take up your doubts now. Okay. And we will wind up the session. Any doubts? Janvi, Pooja, Kundan, Vineet, Aryan. If I miss out any of your names, it's because it's not visible or you have not commented yet. So if you guys have any doubts, please let me know. I'll take up your doubts. Otherwise, we will wind it up here. Okay, thank you very much, guys. That's where I'm going to end the session. See you in the next session. Okay, we'll take it up from here. I'll try to incorporate those points you have told, like putting it, like I'll try to reduce the information from the model answers, and we'll take it up in the next session. Thank you very much. Have a nice day. Thank you.